A very warm welcome to you all this morning. We thank you for being here and for our online audience. I apologize on behalf of us, the management and the department, for the late start, but we're finally here. And just to begin, let's just humble ourselves and pray. Heavenly Father, I want to bless you and indeed thank you, for this is a day that you have made, and we will rejoice and be glad in it. Father, we thank you for this litigation training for the year 2025. We thank you for the participants, oh Lord Jesus. We thank you for our speakers. We pray for your guidance. Holy Spirit, be in our midst, oh God. Father, Lord Jesus, that everything that will be shared and learned will be to the glorification of your name. In Jesus' mighty name I believed and prayed. Amen. So I'd like to take this opportunity this morning to welcome you all, members physically present in the room and on our online audience. Thank you so much. This is a 2-day packed training, litigation, the year 2025, and we are engaging you in so many different aspects. Our first speaker for the day is right here. We are ready to start, and again, I apologize for the late start, but kindly, those who haven't yet joined online, kindly ask your colleagues if they can. Those who are not yet physically here, you can also call up other colleagues that you know that are coming, so that we'll all be here and be able to enjoy this training and learn so much. So right now, kindly allow me to invite our moderator for the day. But before I forget, allow me thank our Radical New Bar, our president, Mr. Isaac Semakade, for being a good leader, the one he is right now, and our ULS management for this opportunity. We thank you all and look forward to your fruitful attendance. Right now, I hand over to our moderator for the day, Ms. Dorothy Amron. Thank you so much.
Hello, thank you so much, Doreen. A round of applause for her. Yes, we need some energy. When you clap, energy transfers across the room. Online participants, thank you so much for joining us. I know that we are great in number. We're about 87, so that is not bad. And then physical, still, the presence is not bad. So I thank you all for making it and for choosing this particular CLE today, because it's part and parcel. We always interact with it every single day. So I am Amron Dorothy. I will be moderating today's training sessions. And with that, allow me spare a moment of silence for the late Pope. We all know that he passed on, and there's a lot of prayer going on for the faithful Catholics and the Christians all over the world, and in Uganda particularly. He touched us in different ways, isn't it? He loved Uganda and he made different visits. So let's just have a moment of silence. Amen. Okay, so we can start the business of the day. I hope that we all were able to access the agenda. If you don't, please check online. I'm sure that Uganda Law Society Secretariat sent you a program online. And I also know that there's a currently ongoing activity honoring the Pope, and the Radical New Bar president is partaking in it. So we'll have divided attention, but I'm sure that we shall also be able to take in and make the most out of today. Yes? Okay, so if you don't have the program or you can't access it swiftly, we shall start with, of course, we're already done with the opening prayers that were given to us by Doreen. And then we're supposed to be already delving into case analysis in the modern age, and that will be a session taken to us through by Mr. Emmanuel, the one and only. He's a special person because he's amassed a lot of experience in practice. He's all around, but most importantly, he's a trial advocacy trainer. So law firms in here, civil society organizations. The first presenter is someone that you'd want to take critical interest in, because It really has a lot of value addition to add in the area of practice. After that, we'll have our tea break sooner. We don't want to deny you the right to food, and we're done with fasting. So you'll have your tea break. And then after, we shall have a session on civil law practice in Uganda, practical insights into effective drafting and case preparation. Yeah? If you fail to prepare, prepare to fail. Yes. So this is also a very interesting session, and it will be taken through to us by Mr. Joseph Chaze. And then we shall have a question and answer, that is a plenary. After the plenary, we shall have opportunities and challenges in commercial and corporate law practice. Specifically, we'll be looking at perspectives from the commercial court and private practice. The panelists shall include Mr. Yusuf Kanyike, Mr. Nasiyama, is it? Patrick. And then the session will be moderated by Stuart Musimenta. After that, we shall still give people an opportunity to have a question and answer. That is a plenary again, because speakers can't be speaking to themselves. And that's why it's important to have a participation online and physically or face-to-face, so that we have those live interactions. We'll have a lunch break. And then after that lunch break, we shall have criminal law in a changing world. And that is modern practice and emerging realities on ground. What are our experiences? So we'll have Miss Immaculate Akutoko, her worship, or his worship, sorry, Kyria Martins. And then we shall have Mr. Evans Ocheng, and then Sylvia Namawaje Ebitud, who will be moderating this particular panel. And then, again, we'll have a moment to reflect after the knowledge that we've taken in. Either ask questions, make comments, clarity, points of clarity, and finally, we shall close off. Remember, this is a 2-day training, yeah? So I'll not delve into day 2, so that you come back here looking forward to the sessions of that day. So with that, online participants, please introduce yourselves, your name, your field or your firm, organization, because we'll not have all the time to, individually introduce, but it would be nice to have people introduce. And for the participants online, before our facilitator comes in, I know that we're not doing so well on time, but I think it's only fair. Where there's a gathering, we know who is in the room, isn't it? Yes, so we'll pass the mic around. I don't know if there's another mic or we'll have to share one mic. Okay, so we'll pass the mic around. For the participants online, keep your details coming through. There's a lot of good morning colleagues, and that is great. Thank you for joining in. We're going to pass the mic around for the physical participants to introduce themselves. Okay, we'll start. Yeah. Your name, law firm, or where you're located at the moment. Thank you.
All right. Good morning, colleagues. My name is Arthur Isaac Amola. I work for New Vision, and I'm happy to be here.
Great, you're welcome.
Good morning, everyone.
Good
Irene
morning.
Nasuna and Company Advocates. Looking forward to a great time.
Great. You can also feel free to share your expectations in a microsecond.
Good morning, everyone. My name is Marion Amtire from Natural and Company Advocates. I'm happy to be here.
Great. Please feel free to share your expectations too.
Good morning, everyone. My name is Justus Agaba. I'm a partner at Lawbridge Advocates and managing the Kampala office.
Great. Thank you for coming.
Good morning, everyone.
Good morning.
I'm Simenta Stewart from S&L Advocates. I will be moderating the corporate and commercial law panel. Thank you. My expectations are high. Thank you.
Great. Thank you.
Good morning, everyone. My name
Good
is
morning.
Deborah Tumukunde, working with New Vision Printing and Publishing Company Limited. Thank you. I expect to be the best.
Okay, amazing. Thank you.
Good morning, everyone.
Good
My
morning.
name is Jocelyn Kengonzi. I work with Tumwesi Jembonya and Company Advocates. We're in Bugolobi. I saw the lineup and I'm expectant. I'm seeing great panelists, so I expect to get the best out of this training.
Great.
Good morning, ladies and gentlemen.
Good morning.
Mugote Ezra is my name. I'm from Semengo and Company Advocates.
Okay. I will skip him. I will save the mic.
Good morning, everyone.
Good morning.
My name is Mary Naroga from Uganda Law Society. I'm expectant.
Great.
Good morning, ladies and gentlemen. My name is Kwezi Asimwe from the Financial Intelligence Authority.
Great. Welcome.
Good morning, ladies and gentlemen. My name is Jovas Chichonjo from the Financial Intelligence Authority.
Great. You're welcome.
Good morning, everyone. My
Good
name
morning.
is Joseph Ndaula. I work with Kayanja and Company Advocates.
You're welcome.
Thank you. Good morning, everyone. I'm Shadia Nakamanya. I work at the Insurance Regulatory Authority of Uganda, and I'm looking forward to fruitful deliberations and discussions.
Great. Thank you. You're welcome. When I say good morning, I'm saying good morning on the rest of it, behalf of everyone. Introduce.
Hello, everyone. My name is Ruth Angom, Program Officer, Professional Development, ULS. Thank you.
Okay, great.
Good morning, everyone. My name is Miss Babian Margaret. I serve as the Program Officer, Members Affairs at the Uganda Law Society. We are happy to have you all. Thank you for honoring our CLE training. Thank you. I hope you learn a lot from the training. Thank you.
Okay, great. Amazing. We have the tech people. They're the ones who are responsible for today's visibility and ensuring that we have online participants following, but also taking in our feedback. I am going to be very alert in terms of time. You joined us. Please introduce in a minute your name and your firm.
Thank you. Good morning, everyone.
Good morning.
David Stephen Kamrasi from Bank of Uganda.
Okay, great. Thank you so much. With that, allow me invite our very first presenter or speaker to take the floor, and that is none other than Mr. Emmanuel Emoru, Senior Counsel. Please, let's applaud him as he takes the floor.
Good morning, ladies and gentlemen.
Good morning.
I don't feel the energy.
Energy, please. Are we together? Or we should first warm up a bit? No? So when he says good morning, it should be filled with energy. Please, back to you.
I will say it again. Good morning, ladies and gentlemen. Good morning. And good morning to the people online. I'm very privileged this morning to be the first presenter at this annual training. And my topic is case analysis in the new modern age. To kickstart my presentation, I'm going to invite a friend of mine, Doreen. She's going to do for us a small demonstration of something we do every day in our homes. Yes, Doreen is, you should come in front here so that we see what you're doing. Yes, we all know what Doreen is holding in her hands. I am sure all of us do this in the mornings. We all dress so smartly so that we appear in court looking very, very sharp, isn't it? If you don't appear sharp, or if you're not fully robed, they tell you, counsel, we cannot see you. So I'm going to have a very small demonstration of things that we do every morning, sometimes in darkness. These days there's load shedding. Eh? Aha. Don't we all wear shirts and other professional attire in the mornings? Okay, so I'm going to ask Doreen to button up that shirt as if she's preparing to go to court. Are you all viewing? Cameraman, please focus on this. Aha. Are we all viewing what's going on? Okay, here is Counsel Doreen Atukunda. Is she looking smart? Huh? What do you observe? Sorry? Let's have some responses. There was a microphone somewhere there. Any comments? How does she look like?
I observe she is not perfectly dressed up in that shirt because the buttons are not in the correct positions.
Yes, the buttons are not in the correct positions. If a lawyer appeared before you like this, what would be the one word you use to describe her? We can start with you.
Disorganized.
Disorganized. Any other?
Unprepared.
Unprepared. Uh-huh.
I'm saying that you can also use the word lousy.
Lousy. Wow. Uh-huh. Any other?
Online too? Do you have any
Yes.
feedback from
Any
online
feedback
participants?
online? Okay, let's be with the participants in the room as we also watch what's happening online. I saw a hand there.
Well, Doreen looks disorganized and you would doubt her.
You doubt her?
Yes.
The key words I've heard: lousy, clumsy, you doubt her, disorganized, unserious, so many things. Let's clap for Doreen. She has demonstrated. Is there any lawyer who wants to go to court and they call you clumsy, lousy, unprepared? Definitely no. So this morning, I'm going to take you through case analysis. And what we want to avoid, and what I hope we can avoid after this training, is appearing in court dressed like my friend Doreen. And the perception you give court is that you're not prepared, you're lousy, you are clumsy, you are disorganized. When you go through what I intend to present, I believe you will be able to create a very different picture. My name is Emoru Emmanuel. I'm a partner, the managing partner at Emoru and Company Advocates on plot 19 Lumumba Avenue. I'm a trainer and a practitioner of trial advocacy. I've trained in many countries in Africa: Malawi, Kenya, Botswana, Uganda, for many years, for over 13 years now. And I'm very humbled to be here as the first presenter. My topic today is case analysis in the new modern age. And please go to the next slide. I want to start off with some definitions. Yes. Now, there is a saying that was given by one of our senior counsel, that is James Mukasa Sebugenyi, that every litigant has 4 tools. Every litigant has 4 tools. That is substantive law. All these acts and statutes that we know of constitute what we call the substantive law, perhaps even the Constitution. The other tool that you have is procedural law. All of us know all those things of Civil Procedure Act. Is it what? Criminal Criminal Procedure Code. And then we also have other rules of procedure in different tribunals and courts. The other tool that a litigant has is evidential law. All these are taught to us in the law school. But there's one thing they don't teach us in law school, and that is the persuasion law. The law to persuade. There are some universal truths about persuasion which have been studied over the years. And part of why these trainings are important is to help you hone skills in how to be more persuasive when you're presenting a case. Now, you may get A+ or first class in substantive law, procedural law, evidential law. You've passed so highly in your undergraduate and the bar course. But if you don't hone the persuasion law, you might as well not become a very good trial lawyer. So my hope, ladies and gentlemen, that at the end of this session, we'll become better persuasive trial lawyers. There's a saying which my colleague posted in one of our groups, that when you have better advocates, you also have better days in court. That if you meet a well-prepared advocate, it's easy for you as an advocate on the opposite side. It's also easy for the trial judge or judicial officer to be able to dispense justice. So persuasion starts with case analysis. Persuasion starts with case analysis. And now I'm going to do some definitions. Can we just have a few people telling us what do they understand by case analysis? Any volunteers? I'm trying to observe online. I hope you're all following. I could read some comments if they appear. Yes. A detailed examination of what is before you. Any other trial or attempt? Did we have a lot to eat for breakfast? What's happening? Yes, who is managing our online? There are 21 new messages. We might be missing very valuable feedback from our participants online. Yes, any other answer? Yes, sir. Understanding and interpreting the case as a whole. Very, very good. Okay, let's go back to my presentation. I came across some definitions of case analysis. One of them is that it is the process of internalizing the case file and laying the foundation for the story to be told. I underlined the word process, and then laying, foundation, and lastly, the story. And I'll get back to that. The next definition. Yes, it is the systematic process of analyzing the legal questions raised by the facts of a client's case. Again, underlined, systematic process, and then legal questions. Lastly, it is the deep critical evaluation of the case file to understand its complexities, identify the issues, and propose solutions. I'm sure with these definitions and those that the participants have given us, we have a fair understanding what case analysis is all about. Next slide, please. So why, don't move very fast. Why do we do case analysis? Number one, it helps us identify the legal issue or issues raised by the factual event. All of us know that every time we appear in court or we're doing a case, we are dealing with facts, isn't it? Something happened somewhere and I've run to you as a lawyer to get justice. Or you're defending someone who has been accused of doing an injustice. So why we do case analysis is to identify the legal issues raised by the factual events. Next. The next is to identify what law governs the legal issue. You remember we started the statutory law? Yes, when you do case analysis, it helps you identify the laws that govern a particular legal issue. If you're doing an environmental case, you might as well now look at all the statutes that relate to environment and the statutory instruments that have been enacted over the years in that particular aspect. The other one is to establish how the law that governs the legal issue applies to the factual event. Case analysis allows you to understand how does that law that I've read or cited apply to the facts that I'm dealing with. And of course, it also helps you to identify what remedies are available to the client. Then the other thing, of course, it helps you identify the nature of evidence needed to prove your case. Many people struggle with this, and with experience, you start learning a few things. The nature of evidence you need, you might want to ask yourself, if I want to prove that this is an expert, what nature of evidence do I need? I need his academic certificate. If it is an assault case, you need a police form 3. If it is a forgery, you need actual evidence of the forged document. If it is a wire transfer, you need evidence of maybe a bank statement that shows that money was moved from this account to another. So that, again, is one of the reasons why we do case analysis. The other thing, of course, is it helps you identify the nature of witnesses that you will need. Please press next. The nature of witnesses you need to prove your case. For instance, if you're tendering a police form 3, that means you need a police surgeon. If you are giving evidence of an IT expert, that means you need to have an IT expert to show that this data message is not tampered with. That also comes down to case analysis. For you to understand that to prove my case, I need this nature of witnesses. Now, case analysis also helps you identify what the opposite side needs to prove to succeed. This is something many practitioners miss out. The illusion that a case has only one side of the story. That is never the case. Even when everyone, the public opinion, has said this man is guilty, the man always has a story to tell. So every time you go to trial, you must also be able to understand what is it that the other opposite side needs to succeed. You may be doing a defamation case. They've raised a defense of qualified privilege. Now you need to ask yourself, as the lawyer for the plaintiff, what does the other side have to prove to succeed in the defense of qualified privilege? It helps you prepare better for your case. Then it could also mean you have weaknesses in your case, which the other opposite side will exploit to your disadvantage. For instance, you're trying to seek compensation for a border rider. He was not wearing a helmet. Don't you think that's a very bad fact for you? And the other people will be really jumping on you like lions, saying, the man did not even have a helmet, didn't have a rider's license or driving license, all that. So you must also understand the weaknesses of your case. That is through case analysis. The other thing, of course, a case analysis allows you to identify the remedies available. Then you choose the best option for the client to get the best outcome. There are a number of lawyers who believe in litigation. And sometimes you may find that solving the problem means getting into negotiations with the person who is suing you, or concluding things at a level of mediation. Are we together? But a lawyer will say, let's go to court. Yeah? Yet, when you do case analysis, you'll be able to genuinely advise a litigant or a client that this is a matter that can be settled, or just advise them that this case will be settled on only one issue. The issue is here, and we must succeed on this particular issue. And that comes down to very good case analysis. Of course, the other last aspect of case analysis is it helps you develop a case strategy. Okay? There are times where lawyers really ignore this aspect. You just let me use the colloquial language, that you just go and knock litigation without having any strategy. For instance, you may want to win a case on a point of law. Now you read the authorities that are saying a point of law must be on a pure point of law. It shouldn't be one which should be raised when there is need to adduce evidence. Now you may go and make an application on a point of law, and yet they are saying you need evidence on record to make your point of law. Now once you do effective case analysis, you'll be able to develop a very good winning strategy to help you win the case. Are we together? That is why we encourage that you do case analysis. Now the one key thing that we need to understand about trials is that a trial is about storytelling. And I want us to get this from here, that trial is storytelling. And you know what they say about storytelling? That the person who tells the best story wins the day, isn't it? And I always pick inspiration from the Bible, that when you look at the creation story and the fall of man, we all know that God is omnipotent, is omnipresent, is omniscient, isn't it? But when Adam and Eve ate the forbidden fruit, he could have just passed judgment because he saw what was happening, isn't it? But he asked Adam, who told you you are naked? And Adam replied, it is the woman you gave me who gave me the fruit and I ate it, isn't it? Then he also asked the woman. The woman said it is the snake. The Bible doesn't say whether they asked the snake. I think the snake was condemned and had. But God went on to pronounce judgment. What does that show you? That even the creation of man, and I believe we're all made in the images of God, we're hardwired to listen to stories. Are we together? When you come to the New Testament, we are told of many teachings by our Lord Jesus Christ. And in all his teachings, he was using parables, isn't it? We all believe Jesus is God. You could have just said, let there be knowledge. Isn't that so? And everyone gets knowledge. But poor man had to go through telling people stories through parables. We all know these parables. Some of the parables which are popular are which ones? The parable of Good Samaritan, of the sower, prodigal son, talents, mustard seed. Which other ones? And you see that because they are told as stories, we easily relate with them. And that speaks to our humanity, that we are hardwired to listen to stories. When you go to hospital, the doctor will ask you for a story. When did the illness start? Where were you feeling the pain? You're telling, if you're driving to Kabira Country Club and you find people gathered, you go and check. You want to hear the story. The question you ask is, what happened? Isn't it? You won't even be asking, who is that? You'll be asking, what happened? What is happening here? You want to hear a story. Now, there's a tendency of lawyers thinking that when you go to court, it's about codes and statutes and the law and what, and forgetting that it's an opportunity to tell a story. Even in our olden days, we would gather around a fire to listen to stories. Now, when you see these judges all in robes and wigs, you think they don't want to listen to stories. They're actually there to listen to stories. They will see a litigant, his shirt is torn, and what they want to know, what happened to that gentleman? Okay? And you tell the story about the gentleman they're seeing, and that is what they want to do. So what are the three main elements of an effective story? Number one, it must be accurate. If you don't give an accurate story, you'll be having issues with your, people won't believe you actually, credibility. So the story must be accurate. Number two, it must be well structured. Well structured means know what to start with, know what to end with, start strong, end strong, pause. The way you deliver it must be very well structured. Okay? You've heard of these people who you get in a wrong, but after he explains, you've all come very angry. Then when you listen to his explanation, all of you start doubting. But I think even if it was me, I think I would have done the same thing, isn't it? Because the man has structured his story, or woman has structured her story in such an interesting way, and you flow with it. Lastly, it must be believable. That's what makes a very good story. You must be able to make the person you're addressing believe your story. So, case analysis has 4 essential steps. Number one, you need to identify the cause of action, or the offenses you're dealing with, or the defense applicable to the facts. I'll just break it down. If it is a civil matter, we all know auto garage versus motor cove. You need to show what right was enjoyed, the infringement, and that the defendant is liable, isn't it? If you're doing a case of misrepresentation, you know what you need to show. Okay? If you're doing a criminal matter, you also remember at LDC they would ask us, what offenses do the facts disclose, isn't it? And this comes down to your reading of the law at undergraduate and law development center. You already know. Even as you listen to the story by the client, your mind is already working around, this is robbery. Then as it continues, it says this is aggravated. You're building up because you already have that body of knowledge in your head. So you must be able to identify the cause of action, the offenses, or if you're lawyer for the defense, you should be now analyzing what defense is the best here. Okay? What defense do these facts disclose? Okay? If it is a defamation case, you're saying maybe is rotating around truth, fair comment, or privilege. And if it is privilege, is it absolute or qualified? If it is a trademark infringement, maybe it's talking about fair use of the trademark. Okay? And many other defenses that you must be knowing better than me. If you're doing criminal, you're looking at defenses like alibi, intoxication, provocation, and many others that we know very well. So all those come to case analysis. The other thing, of course, is the second step is identify the elements of that cause of action, offenses, or defense. I'm sure we all know that every cause of action has things you must prove, isn't it? Now, if you don't go through that process in your case analysis, you end up doing a case, and when you reach submission stage is when you realize, I should have done money had and received. This is not misrepresentation. It's not even breach of contract, because now you miss the elements that you need to prove. Are we together? So those elements, let's say if you're doing a case of negligence, what are the elements? Duty of care, what else? Breach of the duty, causation and damage. So, yes? Foreseeability, yes. That ties with causation. So if you are listening to a client and you're analyzing the case, you keep listing those elements that have to be proved. What does that do? It helps you make even better pleadings, because you'll know that as I write my plaint, I must show a duty of what? Of care. I must show the breach. I must show causation. I must show damage. If you have those elements underlined, then you know that you're going to do very good pleadings. Of course, even for criminal cases, if you want to prove, let's say theft, you must prove that there's a property capable of being what? Stolen. You must also prove asportation, or the taking. You must also prove that there was intention to permanently deprive. Now you must list all those elements, and you ask yourself, what in this case file proves those elements? That is how you effectively prepare. If you're doing a defense, for instance, if you are pleading privilege in a defamation case as a defense, what is it you must prove to show that you fall under that limited bracket of privilege? Are we together? Then you'll be able to make a very good written statement of defense and very good arguments at the end of the case. Then, step 3 is demonstrate how all the elements that make up the cause of action, offense, or defense are present in your case. So from your facts, under each element, enlist what facts show duty of care, what facts show the breach of the duty, what facts show damage, what facts show causation. Are we together? Then you'll be able to know, do I have a good case in this particular cause of action, or I should try another? It's even okay to start with 5 causes of action. But as you list down the facts that fall under each element, you use elimination what? Method, and saying, if I go with this one, I'm more likely to succeed, or if I go with this one, I'm likely to fail. The other unprofessional way is to plead all of them and say, in the alternative, but without prejudice to the foregoing. In the further alternative, you reach the 5th alternative and you wonder what is happening to this lawyer. Because you're not sure where exactly your facts are strongest. Are we together? So I am hoping that after this training we shall avoid lawyers who do alternatives, like 5 of them. With the hope that somehow the judge will see that, okay, this is the best cause of action that would have been demonstrated. And of course, lastly, you have to develop a theory and theme. Theory and theme of your case. I'll delve deeper into that because it's an area which many lawyers struggle with. Even the very experienced lawyers struggle with theme and theory. So let's move on. I need us to distinguish these two aspects: fact versus a conclusion. What is a fact? Can I get some? The answers are already. What is a fact? Hey, come on. What do you understand by it when someone says it is a fact? Okay, a fact is something that can be objectively proved, isn't it? For instance, if I say Amron here has an LLB, I can produce her certificate, isn't it? If I say she has a postgraduate diploma in law, I can produce certificate. If I say that there was a wire transfer done on the 11th of June 2024, I can produce a statement or an EFT request form showing that there was a transfer of money. So a fact is something that can be objectively proved. Are we together? Now, what is a conclusion? A conclusion is, on the other hand, is an inference drawn from facts. Okay? It's an inference drawn from facts. For instance, it could be a fact that, let me use an example. Mr. Odeke took 4 bottles of beer during lunch. That is a fact, isn't it? But as to whether he's drunk, it is a conclusion you want the listener to reach. Okay? The mere fact that someone takes 4 bottles of beer does not mean he is drunk. But you can prove that the person took 4 beers of beer, 4 bottles of beer, by maybe showing the bill that he paid at that time. Or the empty bottles. Some people keep the tops. Yeah, so when you want to make someone reach a conclusion, you must tell the little facts, many facts that lead to a certain conclusion. For instance, if you want court to conclude that Odeke was drunk, you'd perhaps ask him, during lunchtime at Kabira, you took 4 bottles of beer. That's a factual question, isn't it? When you left the restaurant, you went towards the gym, correct? Yes. Your intention was to exit the hotel. Yes. You reached the parking. Yes. You entered the co-driver's seat. Yes. Your intention was to drive the car. Yes. You see that? You're showing a pattern of someone who doesn't know the way out of the hotel. When he reaches the car, instead of entering the driver's seat, entered the co-driver's seat. You could even ask, you gave the parking attendant a tip of 10,000. Yes. Usually give a tip of 1,000. Yes. Now when someone listens to all these facts, they start saying, I go with the witness saying, you are a liar. No, I'm not a liar. Are you a liar? You're a terrible liar, pathetic liar. The witness just tells you, I'm not a your facts. Okay? You perhaps want to demonstrate that this client you're representing is a suffering lady. She has gone through a lot in her home. You bring the little facts that lead to that conclusion. Instead of telling the husband, you've made her suffer. Isn't that true? He will definitely say no. You definitely say what? But if you put him facts that show that actually he has not been treating his lady right, then it's easy for the judge to reach that conclusion. Next slide. Yes. Now, this animal called case theory. What is a case theory? Case theory is when you marry the facts of your story with the applicable law. Are we together? You marry the facts with, just hold on, don't move very fast. Yeah. It's also the legal explanation why you should win. For instance, your case theory could be that he was not there. That's the defense of alibi, isn't it? He was not there. And what criminal law requires that for you to be convicted, you must actually participate in the crime. Are we together? So, case theory also is the legal explanation why your client wins under the facts of the case. Why should your client win? Why should your client win the case? And of course, I was trying to do some research and I found that the earliest documented case theory, which was well articulated, the one which is documented by humans, is in the Bible still. I think it is in Genesis 1, verse 12. I don't know if someone has, they can read for us what that says. Anyone? You can look at Genesis 3, verse 12. That's the fall of man. You are the one with the microphone. You can start from verse 8. Just read for them. Verse 8 to 14. I see NIV here. Yeah, you can use that one. Are we there? Start from 8. Anyone who has reached? Yes? You can read for us. What does it say?
Genesis 3 from verse 8.
Yes.
And they heard the voice of the Lord God walking in the garden in the cool of the day. And Adam and his wife hid themselves from the presence of the Lord God amongst the trees of the garden.
Yes.
And the Lord God called unto Adam and said to him, Where are you? And he said, I heard thy voice in the garden, and I was afraid because I was naked, and I hid myself. And he said, Who told you that you were naked? He said, Have you eaten of the tree whereof I commanded thee not, that thou should not eat? And the man said,
Listen to that.
The woman whom you gave to me, she gave me of the tree, and I did eat.
Okay, are you seeing what Adam is saying? That the woman you gave me is one who gave me the fruit and I ate it. What would that be in law? Superior orders? Compulsion? Are we together? He is articulating a theory why he should win the case, or why judgment should be given in his favor. Are we together? That is what case theory is. You need to be able to tell court, why is it that they should rule in your favor? What is it in the law? For instance, you might be saying that the offenses they are charging this man with, they were not offenses in 1998 when he committed them. Are we together? That will be your theory. And the basis of that is the Constitution, which says no one can be charged with an offense unless it is defined and a penalty prescribed. So you're just saying, yes, he did it, but it was not an offense by that time. Are we together? So that is your theory. Now let's go on to, okay, what a theory should be is that it should be logical, simple, and very captivating. Now, we're going to look at theme. Theme is the emotional core of the case. It's the appeal, that the statement you make that touches the emotions of the judge. Okay? For instance, you might be trying a case of a lady who is having issues. The judge asks you, what is this case about? Then you tell the judge, my lord, this case is about Nancha. She was used, dumped, and now faces eviction from her house. Are we together? Now that touches the emotions of the judge. Used, dumped, and now faces eviction. That is an emotional part of the matter. You could also use an exhibit that you have. Okay? Many of you are familiar with the O.J. Simpson case, isn't it? 1995. Where Cochran, the lawyer, said, if the gloves don't fit, acquit. He picked just one exhibit and said, if the gloves don't fit, you must acquit. And that became the story about the trial. That is the case about gloves not fitting. Isn't that what many people say? Many people forget every other fact about the case, but remember the theme that was used by the defense counsel. The other example I could give you is the famous case of the rape case of the retired Colonel Kiza Besigye. That was in 2001. Yes, it was alleged that he had raped a lady called Chakua. Okay? And the defense lawyers said, of course, their theory was that this is a fabricated case. But how did they say that with a good theme? They said, my lord, this case was cooked in State House, cooked to imperfection at CID, and served raw to the court. Do you see that? Now that statement there really resonates with what the case is about. That is what theme is about. And when you get a good theme, it's like a song, the chorus of a song. Many of you sing, you may listen to a song, you don't know what the words are, but there is that part in the chorus which you know, isn't it? There's a song I always refer to, the one called Chivaluma, that you may forget every other word. You may not even understand Luganda, but you know that at some point I have to say Chivaluma. Are we together? So these judges we see here, they are also human beings. When they go home and their wife or husband asks, how was your day? How was court today? Tells, today I was trying a case of a lady who has been used, dumped, and now faces eviction. Where does she pick that line from? From the lawyer who has articulated a good theme. She will even, I'm trying a case of a bank exploiting people. So all that is what they will remember about the case because you've given it a good headline. You could look at newspaper stories. I like the local tabloids. You see a headline, Chiwede, you pick your money and buy. When you read the story, you say, now, why did I waste my 2,000 buying this? They really sensationalize it and you think that it's really a big story, but it is just the theme or headline I've picked that captivates the attention. Are we together? So what are some of, you can go to the next slide. What are some of the sources of good themes? It could be universal truth. For instance, we all know what goes up must come down. Okay? It could be a good time deserves another. It could also be picked from religious classics. Could be a Bible, it could be the Quran, the Bhagavad Gita, it could be a Hindu text, which have sayings. For instance, if you're doing a trial of unconscionable terms, a money lender has charged someone 20% per month. Someone who borrowed 100 million is supposed to pay 3 billion. Are we together? You could easily say, my Lord, this is a David Goliath story. On one hand, we have this man with his pregnant wife, is desperate, needs money. There's a rich man who is a money lender. And he really forced this man to enter very unfavorable terms. So the David is your client. The Goliath is. And what does the Bible say? God has to assist David to defeat. So the court starts saying, I think I'm the one to help this unfortunate man to overcome this particular problem of a loan shark. Are we together? So you can pick themes from even religious texts. It could be literary works, poems, novels, so many other things, articles. It could also be from our traditional sayings. I know our presidents like, President Choi Museveni likes saying, for us in Ankole, there's a saying that, are we together? There are all those wise sayings we have amongst us. Yeah? I had the opportunity to study in Busoga. There's a saying I came across that when a lizard decides to wear a trouser, it must know where to put the what? The tail. Yeah? So all those things resonate with people and say, this is a very interesting case. So you could pick themes from some of those things. So as I conclude, I want to discuss the best practices. What are some of the things you need to do when you are doing case analysis? Number one, outline the facts of the case. Divide them into good facts and bad facts. Good facts are those that are favorable to your side. Bad facts are those that are not favorable. Are we together? Let's assume you're doing a negligence case. The fact that there was an accident is a good fact. Injury happened, yes. There's a medical report showing that the person started getting convulsions after the accident. Those are all good facts, isn't it? You perhaps also have the fact that someone saw the defendant taking beer at lunchtime. Okay? Those are all facts that support your case. But like I said, there are always two sides of the story. You could also find that, the man who was knocked was not wearing a helmet, isn't it? Maybe he doesn't have a driver's license. It could also be that when he got the accident and went to hospital, they only gave him paracetamol. He only started experiencing seizures after another attack during a rugby game. So now the question is, which accident? Is it the one during the rugby game or the one of the collision with the car? People start questioning what is the cause of the seizures or convulsions. So all that helps. It helps a lot when you divide your facts into good and bad facts. Okay? Now, you need to rank your best good facts. Ranking means If you had 1 minute with God and you want justice for your client, what are those 3 things you tell him that will give you a verdict on your side? What are those best 3 facts that whatever it is, you need to prove? You've seen this in practice. A judge is new in the matter. He asks you, what is this case about? What are those 3 facts that you need to put on the table that will make the judge believe, oh, I think the case tilts more in favor of this one than the other? So when you rank them, it will help you know what are those facts that I must prove in order to be able to succeed. Of course, you also have to rank your worst facts. What are those bad facts that will injure you? And it helps a lot to know that there are also bad facts. Now, the other question that comes, how do you deal with bad facts? How do you deal with bad facts? There are people who choose to ignore. You go and pray that I hope the other lawyer doesn't see this bad fact. Or the judge will also miss it. But how often does it happen? Most times, even when the other lawyer has not seen the bad fact, the judge will be able to what? To see. So is that a recommended approach? No. Do not ignore bad facts. There are those who choose to acknowledge. You just acknowledge. My lord, it is true that day was not wearing a helmet. But let's look at this old man. He's poor. How does that answer the issue? So acknowledging is not proper. There are even those who choose to explain that yes, he was not wearing a helmet, but court should take judicial notice that in Kampala, most border riders do not wear helmets. Or you start saying, oh, his wife was delivering, he left home in a hurry, so he forgot the helmet. You're trying to explain your bad fact. Now, what do we recommend to do with bad facts? We recommend that you turn the bad facts into good facts. I don't know if many of you know the judo law, where you use your opponent's strength to your advantage. Okay? You turn their strength into your strength. For instance, if there's a bad fact about not wearing a helmet, and the map the traffic officer drew shows that at the point of impact he flew maybe 5 meters and hit his head down, you would perhaps say, my lord, you can imagine flying 5 meters without a helmet and you land head first on tarmac. Now what are you proving? Damages. Yeah? That actually, if someone flies 5 meters and lands head first, it is possible the convulsions and the seizures are a result of that accident. Are we together? Instead of looking at it as a really bad fact and say, we are sorry, you now turn it into a good fact for you, which helps you prove some other element in your case. Okay? Are we together? So that's how you deal with bad facts. Of course, read widely. That's another best practice. I always say that when I was starting practice, I entered an office of a lawyer, and he had put there a big signpost saying a lawyer's stock in trade, his time and what? And advice, isn't it? That when you enter a lawyer's office, you don't see blue band and bread that you're exchanging money for a product. What you're paying for is his time and what? And advice and his brains. So as a lawyer, it is in your selfish interest to develop your body of knowledge so that when you're giving advice, comes from a rich collection, an arsenal of knowledge which you have developed. Are we together? Instead of remaining on the surface, you must now go deep. And time will come where you'll tell a client, if you're not paying 50 million, I think I can refer you to some lawyer I know. Because you've reached a level where you've read your books and you can now charge a premium for your services. Because your stock in trade is what? Your advice. The quality of advice depends on the knowledge you've accumulated. If you don't have the knowledge, then you're going to give very bad advice. So read widely, because when you read widely, you'll be able to know the elements that you need to prove, what the cases say about this particular issue, what do the things say. All those things are in your mind. Who succeeded? Why did they succeed? Who failed? I see many people struggling, even just applications. You've gone for a temporary injunction. You know you must prove prima facie case, irreparable damage. And if there's doubt on the two, they decide the case on a balance of convenience, isn't it? So you must be able to show those ones. And now you'll be able to know that this guy failed because he failed to show irreparable damage, or he succeeded because he managed to show that. The same with stay of execution. I've seen many applications collapsing because there's no threat of execution. You've filed pleadings, files and files with separators, very clean work. Then you lose the case just because you failed to demonstrate a threat of execution. How do you miss that if you've done case analysis? The authority will also tell you what amounts to threat. If someone taxes their bill of costs, is that a threat of execution? The authority will say it is not. You must present an application for execution. Present an eviction letter. Present something which shows that they are now trying to execute the decree or order. But now if you're preparing that application and you fail to show threat of execution, you'll definitely reach there and they knock you out on just that single point. And you start alleging, I think they've given him money. Lawyers have that default thing they tell clients. Yet in your heart you know, I am the one who messed up this case. So ladies and gentlemen, there is also the aspect of working in groups. I know many lawyers who have farm meetings. I also know many who don't have. You run the farm like a kiosk, yeah, which is not a healthy practice. If you have lawyers, however junior they are, sit with them and analyze a case. They will have very valuable information. They could have an authority they know which is helping your case. Are we together? They could pick out some evidence which helps you win the case. Don't underestimate that. One of my favorite writers says that a fly without an advisor does what? Follows the corpse to the grave. Yeah? A fly without an advisor follows the corpse to the grave. So when you have people around you with legal knowledge, utilize them. Work in groups, you'll be able to make very good case analysis. Closely connected to that is the aspect of consulting. Don't fear to call Mr. Moru. Don't fear to call senior counsel somewhere and say, I'm dealing with this case. You could even know that, this matter was done by Counsel Muema or Chiriowa or who. You call them. Call them and ask, you did pleadings in this matter. Can I have a copy of your what? Of your pleadings? Can I look at your final arguments? Let me look at your... All those things help you prepare. Because then you'll understand where they failed or where they succeeded. And that helps you make very good case analysis. Of course, I've labored on theory and theme. I don't want us to be, and I don't want to repeat what I said, I don't want us to be that lawyer who says, my lord, the accused was not there. But if it was there, He was acting in self-defense. If it was not self-defense, he was provoked. If he was not provoked, he was intoxicated. Now, what do you want the court to take? Is it alibi? Is it the self-defense? Is it provocation? Is it intoxication? But somehow you want to put alternatives that if I fail. Now some of those defenses are mutually exclusive. You can't have all of them in one case. Are we together? So when you get your theme, a theory clear, you will avoid such as the shirt and even knows that there's a spare button somewhere here. It is not for buttoning, it is just a spare. Should button very well, should look prepared, should look very persuasive just from her dressing, and that is how you manage to win a case. So with that, I beg to end here. I thank you all for listening. I hope the people online have followed what I've said, and I would like to invite questions if there are any. Otherwise, thank you for being a great audience. I thank you. Yeah, any comments or questions? Of course, the other thing I didn't mention is that
Recording in progress. Recording in progress.
My question is, in coming up with a theme, what should be your limitation?
I didn't hear the last word. What should be?
What your limitation?
Okay.
Yes, you gave us an example of Goliath.
David Goliath.
Oh yes, David Goliath. What if now the judge handling the case is a Muslim? I'm counsel for the plaintiff or whatever, and then the other party is a Muslim too. Thank you.
Okay, thank you for that. Do I take a set of questions and answer, or?
Thank you very much, Mr. Presenter. You did mention understanding the weakness of the case. And from my experience, actually lawyers, we don't want to hear the weakness of our cases. Some time back, I had a matter with a colleague, and I remember when I started to point out the weaknesses of our own case, I remember him posing a question that, counsel, which side are you representing? Are you still representing our client, or you have shifted to the other side? Then the other thing, which I didn't get from you as you do case analysis, is actually the admissions therein in the pleadings themselves. Sometimes as you read the opposite counsel's pleadings, you realize that he has actually made some statements which are very helpful to your case. Thereby you could also, at some point, capitalize on them. Thank you very much.
Thank you. Yes, I see Birunji Bridget say, counsel, please share on the tips young lawyers can use to better themselves, because some senior advocates are too mean, especially when it comes to mentorship at firms. Thanks. Okay, thank you. Thank you, Birunji. Is there any other? Okay, there is a hand there.
Mine is not a question. I think it is a guideline. After about 25 years of practice, I think I can say something. I had a case. The house was not in a road reserve. It was just a house. The lorry parked, the brakes failed, and the lorry rolled into a house. And I was the defense lawyer for the owner of the lorry. I mean, it's not an easy task. What I did was to look at the facts. They were extremely unfavorable. And my colleague told me, we don't have a defense. Because you see, this is a building, it is 50 meters away. The lorry came at high speed and bumped into a building. So what I did, I looked at the prayers in the plaint. The prayers were that there was a damage which needed to be made good, restitution. 2, there was loss of income because this building was being rented out, and other damages of inconveniences, things like that. So my defense was as follows. After failing to get what to do, and I needed to force this individual into alternative dispute resolution without high expectation. So I said, we shall request to see the occupation permit of the building to show that this building was legally, first of all, that it was legally built where it was built. 30 years ago, we needed approved plans because this was a town, and for a town building to be built, you need approved plans. So we needed to look at them. You know, interrogatories and further information which you can seek. Number 2, we shall seek the URA returns of the claimant to confirm that this property is being rented and how much is being rented through URA reports. And of course, the occupation permit to show that this property is being properly occupied since it is in the municipality. So, to cut the story short, we actually also reached the point to look at the strength of the building by getting an analysis of the building materials, the extent of the damage, because this was a single track. If a single track enters a building, how much damage should be? Did you use the right cement? So we got also a person who, from Makerere University, who analyzes the strength of the building materials. Now, after a number of years of meetings and going up and down, we sat on a table because after writing to URA wrote back and said, we do not have this person in our system, we don't have his TIN number. So I put that one aside. Then also the report from Makerere showed that these materials were not the right ones, and that this building was also unfinished and not fit for occupation. With that, we sat on a table and solved the case with minimum expectation. Thank you very much.
Thank you. This is the beauty of having people with good experience in the audience. There are now many. Let me take this first set of questions. I'll start with you, sir. I didn't get your name. Brian Musika. His story is a clear demonstration of what I explained is the purpose of one of the objectives of case analysis. It helps you get a case strategy. He realized on the merits of the case, he might not what? Win. But he can aim at settlement, but how is he helping the client to minimize the amount of money paid out as compensation? That is his strategy. That I'm going to settle this case, but at a minimal cost. So now that helped him work backwards after analyzing the case. That I need to see occupation permit, I need to see approved plans, I need to see that. Whenever the other person hears that, he starts saying, I think I might lose the what? So that comes down to case strategy. So I'm happy that he has given an example which clearly illustrates the benefits of doing a good case analysis. As was proceeding, another comment came saying, thanks for the presentation. Should case analysis be litigation oriented, or it can also be mediatory oriented, where you identify points of resolution within the facts? Again, his example is one of these. And just to answer the question, case analysis is a skill which is all round. It is all round. You could use it for preparing for litigation. It could be for mediation. It could even be your son has misbehaved at school, and you're trying to analyze the what? The case and the strategy how to approach the matter. It could be a meeting. You could be going for contract negotiations. When you go through that pain of preparing your good facts and bad facts, it will help you make a good negotiator. So just to answer Waholi Alan, yes, case analysis can be done not just for litigation, for mediation and all other aspects that a lawyer does in his daily life. Okay? But don't extend it to homes. You may you may become very difficult to manage. Yes, the next the other question, they're not in a particular order, I just noted them. There was a question of sharing with young lawyers how they can better themselves because some senior lawyers are too mean. I just want to say these two things. Number one, as a young lawyer, every opportunity you get is a learning opportunity or a mentoring opportunity. As a young lawyer, I got mentored by John Mary Mugisha, senior counsel. And I didn't wait for him to sit with me, to sit and lecture me. I would observe what he does, the corrections he makes on my pleadings, the way he presents in court. I would reach court very early so that I see how other lawyers are approaching, how they are being grilled. There's a session I attended where one of my lecturers at LDC had filed a summary suit without a supporting affidavit. So I think he saw it that morning. They called his file and he said, my lord, I am withdrawing the application. Yeah? I'm withdrawing the suit rather. The judge said, no, come back here, counsel. Aren't you a lecturer in LDC? How can you do a summary suit without supporting affidavit? Are we together? Now that was not my case. I was not enlisted to be mentored, but because I went to court early, I got mentorship. That actually, don't take anything for granted. Even if you give your associate work to do, cross-check it to make sure that you've met all the requirements of the law. It was very embarrassing. Could have just withdrawn the matter before that day, but he waited until they called the what? I think he realized there when the file was brought. So mentorship is something that you should not wait for opportunity that now mentoring you. It should be your call as a young lawyer to learn from what other lawyers, not necessarily your mentor, but even what other lawyers go through. The first time I appeared in Supreme Court, I attended Supreme Court without even having a case. I just wanted to remove fear, because they had told me there's a lawyer who sweated and sweat could be seen from the gown. I said, I don't want that experience. Then I realized they're actually friendly. Once in a while, Justice Kanyahamba would raise his voice, then the lawyer responds, then they laugh. I said, it's not a very dangerous place, really. And that was mentorship for me. I didn't have to wait to say, you come, go with me to court. So as a young lawyer, yes, it is true some lawyers, senior lawyers are mean, but that shouldn't define you. You should actually get a chance to learn from every opportunity that presents itself. For mentorship, these workshops that ULS is organizing are part of the mentorship processes. I think even my presentation is part of mentorship. And I would encourage ULS to arrange more of such programs for young lawyers so that they learn. Because when you have a good bar, you actually get a good bench and get quality decisions. For instance, if you analyze the case, both defense and plaintiff's counsel, then you've zeroed down on the issue, just one issue. You will meet in court and say, my lord, this case rotates around one issue, and that's what you want court to resolve. You don't waste time. There you get judgment faster and everybody goes home. So I just want to encourage again young lawyers, take advantage of all opportunities to learn. And if your senior lawyer in the firm is not responsive or is mean, there are many lawyers in town I know of who you can approach and they will mentor you. They will mentor you. They will tell you, I'm going to court today. If you have time, you come. Not that you're an associate in their firm, but I just want you to be there and watch how they conduct affairs. And that is part of mentorship. So don't be caged with a mean lawyer and don't progress your knowledge gap. Don't cover your knowledge gap. The other question was not even a question, but a comment, that there are times where there are admissions in pleadings. Yes, this is one aspect, especially when you are defense counsel or even plaintiff's counsel. You see in the pleadings that there are admissions. Now, when you do case analysis, you'll be able to get a proper strategy. For instance, for where there are admissions, you can say, let me apply for a judgment on admission, so that those matters are not disputed. Or even in your scheduling conference, you'll be able to quickly point out agreed facts. You don't have to bother a lot. But if you don't do case analysis, you'll miss out even where there are admissions. So again, it rotates around the aspect of case analysis. He also made a comment about weaknesses, lawyers not taking time to understand the weakness of the case. And it's true, there are times when clients even ask you, but on whose side are you? That's a very healthy question. But my response always is, when you're in a war and everything is very peaceful, just know you're in an ambush. When you're walking, they tell LRA is here. You walk 3 kilometers, nothing is happening. You should be very worried. So the approach is, be the devil's advocate in your own case, because then it will help you prepare pleadings better, to make you make better arguments. Because now you do what they call preemptive attacks. Even when the case is not favorable, you are the one who brings out the facts to the fore. So let's make it a habit, and we shouldn't fear being asked this question, but on whose side are you? Explain to the client why it is important to understand the weaknesses of your case, and they will actually understand and support you in that course of action. The first question I got was, what are the limitations on how you develop a theme? You could be citing the Bible. Judicial officer is is a Muslim. One, I think religion shouldn't be a factor in judicial decisions. I believe they took oath to administer justice without fear or favor. But I hasten to add that one of the key things of being a successful trial lawyer is to know the judge. To know the what? If it is a panel of judges, know your panel of judges. Unfortunately, in this country and many sub-Saharan countries, when you say know the judge, people think of something else. They think you must know his mother, his father, his best man, maid of honor, the one who can talk to him from behind, so that you get a favorable. Knowing the judge is knowing the person you are appearing before. There are judges who give you time, you explain, you make mistakes, they are quiet listening. There are also those who are impatient. Then there are those who are so inclined to technicalities. You know that, if I appear before this one and I plead limitation, I succeed. There are those who will say, now there are those who are saying, let's go to the gist of the matter. You've raised an objection that this company, its articles don't have a clause restricting transfer of shares to non-citizens. So this is a non-citizen company. You reach the judge and judge says, no. Let us go to the to the merits of the what? Of the case. Now there are judges who will take that as a legal point and determine the case on that technicality. There are those who will not want to listen to use chamber summons instead of notice of motion. They will say, have you read Sagu versus Roadmaster? Okay? They will really dismiss you and you don't even waste time. When you know that you're before such a judge, don't even start raising those small things. That I supposed to be a chamber summons. These ones are used the notice of motion. They'll really think you are not prepared. So, themes, and I'll say this again, you can even start with several themes, but you keep eliminating them, looking at the judge you're appearing before, the kind of things they will resonate with. For instance, there was a matter I was doing and I knew the judge has a forest. So I brought examples of and saying that relate to trees, and I saw the judge resonating with what I was saying was relating to what I was talking about. Now, understanding the court you're appearing before is also very important. So there is no limitation on themes. The approach we suggest is try different themes. You can even start one theme and realize, but my facts will not prove this particular theme. Let me change it to something different. So you keep trying. Don't even be afraid that the morning of the trial you don't have a proper theme. It can come in the heat of the moment. When they're doing the case file before they call yours, you say, by that statement the judge has mentioned fits well with my case. So you develop a theme along those lines. So thank you. I hope I've answered your questions. And if there are there any other questions or clarifications? Yeah, I assume that we are done. I beg to end here because if I continue, I'll become irrelevant. I thank you, ladies and gentlemen.
Oh, wow. Louder for Mr. Emmanuel. It's squared. I think he's really done justice to the first presentation. And I'd like to thank the online participants too. We had comments from Akelo, Percy, commenting earlier on in terms of the questions that were posed. We also had Nur Nachibuka Musisi share with us. So we encourage online participants to also be active. So we acknowledge and appreciate Birunji, Alan, for sending through their comments. Yes, and the rest of the online participants who introduced themselves. Isaac, Ronald, thank you for your comments. Kindly note that they are coming through and we are ably reading them. With that, I think we shall break for tea break. And it can be a working tea, but Mr. Mori, you may not have to run away fast, because I know when there's been a knowledge sharing, it takes time to process, right? And we might look like the program is still overwhelming, but I think your first presentation really sets the pace. And I'm also informed that we still have enough time to delve further into case preparation. I know most of us are curious, is it litigation only about court? Some of us, preparation, forums, what kind of court, who are the parties, all this. Council Emoru has really taken us through and opened our eyes. It feels like we're going back to a refresher training, and really this is very important, especially for the young lawyers, but also senior lawyers, because not everybody takes on litigation as the core. But you don't know where practice takes you. Today you're in government, tomorrow you're in civil society, and today you're back into practice. So it's important for us to be all-rounders, and we really would like to thank you so much from the bottom of our hearts. Personally, I was also taking notes. You learn every day, and it's quite humbling. You have to be willing to be a learner every single day. And I think the weight is upon us. Cases, the stories, it's about preparation. If you fail to prepare, plan to fail, isn't it? Yeah, so there's no magic. Everybody was at that point of shaking. Mr. Moore has shared with us his strategies. He went to courts early enough to observe, so that is being proactive. You need to be very proactive. Opportunities don't wait for you seated. You have to knock those doors. Some of them I hear are not exactly closed. So when you push further, those opportunities for you to learn showcase themselves. So we're going to have a working tea. For the online participants, please stay with us. You can stretch, you can grab a cup of coffee wherever you're seated, but also reflect further. We are trying to buy time for the next presentations, but in the meantime, from the first presentation, you can also share your experiences. Are there any additions? Are there interesting insights that you learned along the way? And how do we cross-fertilize those experiences with the presentation that Mr. Okanso Emmanuel Emoru has shared with us? Yeah? So please stretch. Sitting is also one of the non-communicable diseases of late. Too much sitting, we need to stretch. But keep your comments coming through. Yes. Okay, so we're going to have about 15 minutes to hear from Counsel Nasinyama Patrick on civil law practice in Uganda. We don't have Counsel Joseph Chaze here, but Counsel Patrick is willing to share with us a few insights briefly in terms of civil law practice in Uganda. He'll be sharing with us practical insights into effective drafting and case preparation. I guess the principle of effective drafting and case preparation cuts across, be it civil, be it commercial, be it family, be it corporate, you know, it cuts across. So we're very humbled that you're going to be sharing with us. So allow me hand over the mic in the interest of time. And the participants can also feel free to add up, but we just didn't want to skip this because we have so many people eager and avid to listen in, especially the young lawyers. So let's share, bear with us, we'll share for 15 minutes, then we'll delve into the panel. Is that okay? Okay, great.
Okay, thank you for this opportunity. Good morning, fellow colleagues. Okay, Patrick Nasinyama is my name. I am an advocate in private practice. So basically, I enjoy being on the Ugandan streets and making it happen out there. So I've been asked to give a word or two in regard to what Mr. Joseph Chaze was supposed to handle, and he's currently indisposed. So I'll make it an interactive session so that perhaps it is one that we can pick a thing or two. As I'm hoping that everyone are we all litigators? Are all of us in private practice, or some of us are in-house counsel? In-house. Okay. Well, I'll start with a basic question. Where do we think cases are won? Maybe that's where we can start here. Do we have an idea? Where are cases won? Yes, madam. On paper. At the? Yes, I think your answer, well, yes, I do agree with you in the sense that it is true. Cases are actually won in chambers on your desk, okay? I know most people think cases are won in court, or they are won wherever, before a tribunal, or they are won by being so eloquent, or they are won by, other means. But essentially, cases, you start to win your case on your desk. It's actually won on your desk as a pleader, or as if you're in-house counsel and you're putting across a strategy to the board or whatever, it's won right there because you come up with a strategy, okay? Does anyone, when I say litigation strategy, are we together? Yes? Because the first thing you do as a practitioner when you get, I don't know, for me, who gets instructions, or for you when you get orders from your senior, the first thing you do, of course, is, assimilate what has been given to you and come up with a strategy as to how you're going to conduct that. Now, I'm going to restrict myself to effective drafting and case preparation. And from my experience, drawing from my experience, I believe when you get the instructions or you get the orders from a senior in-house counsel, I don't know who gives you the orders, but when you're given the task, you start by sitting down, of course, assimilating what you're supposed to do, and then you go ahead and come up with I'll use me who's in private practice. You have to craft a litigation strategy. It's the first thing you do. What exactly do you intend to achieve from your case? It is not that when you get instructions, your case is, your objective is to win the case, okay? Many people think when you have instructions as counsel, the first thing at the back of your mind is to win the case. The question is, what is your litigation strategy? Am I buying time for my client? Is that tenable ethically? Does your client need time? Okay? You see, because you may be going to court to buy your client time, and counsel may think you're there to argue the case. So they see sloppy pleading and they start thinking that counsel is here on serious business. No, it may not be counsel's litigation strategy. And I'm always constrained to believe when I receive pleadings, no matter how sloppy they look, my question at the back of my mind is, what is the strategy of counsel? Are they looking to disorganize us? Do they have a serious case they're articulating? Do they want us to actually litigate this case? Are they buying time for their client? What is the strategy behind this litigation? So that's the first question you ask yourself. What's my strategy? Am I pushing this case to win it? How long am I going to take to win this case? With our practice, your objective timeline is about minimally 3-5 years, right? I think in practice, if you're looking to be objective, if you're lucky, 2 years. But averagely, you're looking at a period of about 3 to 5 years to litigate a case to conclusion. You'll be surprised, even a summary suit will take a bit of time, which it shouldn't. But essentially, it goes down to litigation strategy. And as a practitioner, that's the first thing that should be on your mind. What do I need to achieve for my client? Is it time? Am I looking for a win? Am I looking for an interlocutory remedy, injunctive relief, whatever it is? So that you focus on the outcome. I find a lot of people waste time. You want to have the perfect case, okay? You know, you want to win on everything, and then you lose sight of what your objective is, okay? So pleading, drafting, that comes to mind. 2, of course, knowledge of the law, which many of us, you know, don't take seriously, but knowledge of the law is important. And with our changing jurisprudential space, you must be abreast with the law. Some of us take it for granted, but lots of people are losing cases on points of law because you make mistakes at drafting. You're putting in a suit and you don't know that this contract was executed more than 6 years ago, and you go to court. Okay, something that's simple. Some of us, I have been in cases where people have been embarrassed by not knowing the limitation for cases premised on contract. You're taking a suit for a tort and it's over 3 years, okay? So it is embarrassing, especially when you are a senior advocate or somebody who has been in practice for a while and you don't pay attention to the basic tenets of the law. So civil law practice these days, and you will find a lot of preliminary objections on points of law where people are tested on their knowledge of the law. So one of the core tenets that you must have is you must appraise yourself with the law. This suit that I'm taking to court, do I have locus standi before court? Does the court, can I get audience? Okay, if it is a suit premised on the Law Reform Miscellaneous Provisions Act, and the person, your client before you, is a friend of the deceased, okay, can they sue? Okay, yeah. If it's the mother of the deceased and has no letters of administration, can they sue? You know, you have to ask yourself all these questions, because one of the things we are having is a lot of people being embarrassed on basic principles of the law. And of course, there are more sophisticated principles where you would say perhaps people are not appraised, but as counsel, you must have the latest position of the law at your fingertips. Yeah, quoting wrong law. It's embarrassing. We have had an amendment of the laws. People are still quoting the old law and going to court. And of course, the first thing is procedural matters are not fundamental defects. That's the first thing you say. If you're before a judicial officer, do you think they take you seriously? If you're counsel presenting a case and you're quoting wrong law? You see? Those are basic tenets. You need to be appraised on the position of the law, what has changed in the matters that you are instituting. So litigation strategy, knowledge of the law are core to practice or to presentment of whatever issues you are as counsel in our time. Then, of course, we also have, perhaps I'll make a comment on this, we have become lazy as counsel to, one, peruse documents and peruse the law. We rely so much on AI now. I've seen people who present submissions that have been entirely crafted by artificial intelligence. You put in a prompt on, you're making submissions on an injunction, and you just prompt it and say, draft an injunction submissions in relation to Ugandan law. And it does give you a whole outline of a brief, you know, submission. And you don't even bother to proofread. And it's quoting cases that actually don't exist. Yeah? And I'm telling you, these are things that are happening. Okay? You will go to court and people are presenting AI-generated submissions. So some of the things you should essentially warn yourself on. AI is good, makes work easier, but it is not entirely correct. It's still in its early stages. It does not have a firm, grasp of the law as is. It picks out a few principles, but does not solve the problem of lack of knowledge. So some of us are relying entirely on AI. I have clients who send you their submissions now. They write their own submissions and send you counsel to read and endorse. I'm telling you, seriously. A client says we are going for this, but for me, I've written my submissions. You look at them and you see if you're adding anything, or we just submit. And you are counsel. So that means clients are starting to make their own pleadings. Because basically they give you the instructions, they're the ones paying. How do you say no to them? Okay? And yet when they go before a doctor, they pay a lot of money, and probably the guy goes on Google and treats them with the aspirin, which they could find, right? So I think in our time, it's becoming a little tricky. One, how do lawyers, deal with their clients' instructions? They have told you to draft a suit, and your client has even given you the plaint and told you just see what you add, but don't change it. Do you go ahead and put in that plaint, or you go ahead and give your professional opinion and draft something you think is tenable? Okay? This is the time in which we live. In-house counsel now, with also these same facilities, they're giving external counsel instructions and they send you a draft. Our opinion is that this seems to grasp what we are trying to argue. Even the submissions now, in-house counsel is sending to external counsel, and you don't have the latitude now to start, the back and forth arguing with the person who's giving you the instructions. Is it right? Do you think you're going to add value to the suit if people are already relying on these other positions? Perhaps that's why we are having, a stifled growth of jurisprudence these days, because people are relying on what is there. So that means we're not thinking outside the box. We're not arguing the law in ways that actually develop it. So ideally, back to our core, again, litigation strategy, knowledge of the law, very important. And of course, I've talked about knowledge of the law in line with the new developments of AI, of course, and the client expectations of our time. Clients expect us to be more thorough than they are. So you can only be more thorough than your client if you are informed. That means we have to go back to the basics as lawyers. We actually have to do more research and actually read for ourselves. Because now the basics, you're not going to convince your client using cases they can find, principles of Khalil versus Kabolik, Salmon v. Salmon. They understand that. They're looking for what touch to those arguments are we putting across. So basically, the two things that I've emphasized are, as I said, of course, adopt a litigation strategy, know why you're going to court. Don't abuse court process, of course, because perhaps maybe to give an example of strategy and how it plays out. I'll give a live example in the commercial court. How many of us know about the Ham DTB case? Ham DTB? It was all over the papers in its time. Does anybody know? Not the facts. I'm just asking, do we have an idea what it is? Yes. What do you think the litigation strategy was in that case for Ham? I'm just asking. Yes, sir. It was? Delay tactic. Do you agree with him? Yes? No, but let's as lawyers, let's try and dissect this. Can you take money of a bank and not pay it back? Is it possible? Is there anywhere in the world you can argue that that loan is illegal or that you're not going to pay that money? Is there anywhere you can argue that successfully? Yeah? So what do you think when the instructions came to that lawyer, his strategy was? Yeah? Anybody have an idea? So they have given the lawyer instructions. What do you think their strategy was? Exactly. Okay, something like that. But the point is, if you look at it, Ham had 5 years of not paying a single coin on an outstanding loan. But his businesses are making So at the end of 5 years, can't I walk to any bank and tell them this is my cash flow, pay out the other loan, let's restructure this? Don't you think, has the lawyer achieved purpose for the client? Yeah? For us who are in the commercial law space, if you're not, maybe that may look a little, suspect. But you get what strategy is. It is both short-term, long-term. You need to be looking that far. What are we looking at? Is it to get the early win? Is it to deal with the appeals? What does the client get at the end? So that is just a simple example. I'm not saying I can speak for the lawyers who came up with the strategy. No, I'm looking at the strategy from the outside. But I think ultimately the strategy was, let's get our client time to breathe and be able to negotiate it from a stronger position, which I think they have achieved, essentially. As lawyers, to survive, that's how we need to keep thinking, at least in the 21st century. So I don't know if that is adding any value, but that is a snippet of civil law practice in regard to... Did I touch on effective drafting? Yes, I said something about effective drafting. Talked about knowledge, of course, and of course, pleadings. We all know what pleadings are, okay? This essence is having knowledge on what to draft, which comes from basically the law. Case preparation, I have talked about it. Not wholesomely. You may forgive me for touching on so many areas, but essentially it is because I was a seat filler. I hope that adds some value, and we can get the discussion going from there. Moderator, thank you.
Thank you so much, Councillor Patrick, for doing us justice. In a short time, they say you can never ambush a lawyer, yeah? They're always prepared. So you've just proved that to us, and we're deeply grateful. Another round of applause to Council. Yes, I think you touched on so many things, given the few minutes and, the main refocusing, you came ready for a panel, not this presentation, but I'm sure that we've picked up one or two things. And it's at this point that you can feel free to comment, share any additional probably strategies or insights, or even just an appreciation note is welcome. There's a mic. Where's the second mic?
Thank you. Council talked about delaying the delay tactic.
Yes.
So court at the end will award costs. So I felt like asking a question.
Recording in progress.
Sorry. What if now court awards costs that if it was sorted or, handled earlier at mitigation, it would be better. However, as I was still asking myself that question, I came up with an answer, which I would just want to discuss.
Sure.
So in assessing these cases, in analyzing them, we need to assess the risk first. What risk appetite are we taking on? For example, you will see the other council, what damages are they claiming? Like you see, so if your client is going to, or is in position to give those same damages, I think, yeah, you proceed and buy time. That you bear in mind that even at the end, we shall pay costs, but even in paying costs, we have again good profits for ourselves. Yes, so it's just risk appetite to know, can we bear this risk? If we bear it, won't it throw us to the deep end, or it's still manageable? Thank you.
Okay, thank you so much, Council.
Deborah Tumukunde from New Vision Printing.
Okay, Deborah Tumukunde from New Vision. Interesting. She mentions a concept on risk appetite. I don't know how many of us are familiar with these concepts, especially when you're doing case litigation or case conceptualization, because it's at this point that you also review the remedies and you know what you want to achieve. Thank you.
Thank you very much, Mr. Patrick. You mentioned something about lawyers being lazy because of the use of artificial intelligence. I would respectfully disagree, because the use of artificial intelligence is for the skilled mindset. If you were to look at the lawyers of your time or way back, it's quite unfortunate that the lawyers of your time are still finding it difficult to appreciate the use of artificial intelligence in line to drafting. I also have a question. So how would you recommend lawyers in appreciating the principle of artificial intelligence in line to litigation strategy? Because AI is here to stay, but we have a difficulty in regulating policies or documentation of work. So how would you recommend lawyers to appreciate the use of artificial intelligence in helping them achieve their end goal? Thank you.
Okay, AI has come and it's coming and it's going to stay. Yes.
Okay, thank you. Thank you. I'll start with maybe a comment on the strategy and risk appetite and all that. One, I'd like to take the example I did give as for purposes of enhancing our understanding of strategy. But essentially, at the stage of crafting a litigation strategy, you look at all the pros and cons. And of course, you discuss it with your client for them to understand what the stakes are. But if you are good at what you're doing, essentially, at the point at which you get to settle this case, you would have put that into consideration. I can assure you, for example, if you take the harm example, if 120 billion is owing, do you think the bank's biggest problem is? Do you think it's in their mind? If a person says, I'm giving you 120 billion today, are you going to tell them interest? What would you watch by money? You know, so it depends. Strategy is strategy. Again, you put that into consideration. Okay? I'm not saying in every situation. There's somewhere you will have to incur certain costs. There's somewhere you will have to. So it's up to you and strategy. Maybe the other part, when you come up with a strategy, that strategy informs how you litigate your case. Because when you go to court, it's like performing. It's like an orchestra. You planned it out, the notes, and court you're just playing for the judge. It's your strategy playing out. It's like a play, and you're just a showman as a lawyer conducting your strategy. So that means you know how many witnesses you're going to call, what each witness is going to say, and what they bring out. If it's a case, you know that this witness is just coming out to show that that we have a right to sue. This witness is going to show that we got damage, we are entitled to damages. You don't waste time. I have a problem when I go to court and lawyers are asking 100 questions to a witness. For me, that is a sign you don't understand what you're doing. I'm serious. Because when a witness comes, you must have a point. What do you want to say through this witness? It doesn't take more than 10 questions. If you're good counsel, you don't waste time. What does this witness need to say that court needs to hear? Yes? If it was a contract, they either drafted it, they signed it, they saw it. But this is the person you want to prove that the contract was executed and you're asking 100 questions on it. Does it make sense? So that shows poor strategy. But I hope that gives a mindset on strategy and how it plays out. In regard to AI, it's good. I know this generation is obsessed with AI. I'm sorry, true. I'm happy to say, I'm proud to say I come from the generation that read paper, you know, we really relied on paper. But I happen to have the privilege of teaching at the Law Development Center. So I interact with the new generation quite a bit. And I notice they are so into this AI thing. But the reality is AI can only, enhance your flaws, or you can fly with it. If you have a knowledge gap, AI is not going to cover it. You notice? You cannot you can't put a bandage and say AI is going to cover your knowledge gap. You don't have the knowledge, you don't have it. AI is not going, actually you're going to crash because AI is going to give you wrong things and you're going to perpetuate the wrong things. So you must have the basics. I don't want students and young lawyers to go away from the fact that you must have knowledge. If you don't have it, AI is not going to benefit you. Okay? Same thing we're talking about, AI is coming for lawyers' jobs. I believe for basic tasks, yes. Because I mean, in developed jurisdictions, you're not going to go and draft. For example, a contract, it's already online, okay? But it's not going to take away the fact that I know that time is of in a contract. You get it? It's not going to take away the fact that after 30 years of litigation, there are things you pick out. You know that if I put this clause, I'm targeting this ruling of the Supreme Court and all that. So those come from knowledge. So AI is good, it makes work simpler, but you must be informed as counsel. That means you must continue reading, you must continue coming for these CLE sessions so that you appraise yourself. Otherwise, you can't sit back and say, AI will do it for me, I'll just ask AI. Okay? So I'm not against it, but you must do the work to deserve to use it. That's my position. Thank you.
Great. Just hold the mic. You still have some questions coming in from online participants. But just to say AI is our helper. It can learn your style. Eventually, yeah, the more you use it. But you still have to be grounded, like counsel emphasizes. If it's too good to be true, there's a problem. So Counsel Isaac Kabio says, what extremes should strategy go vis-a-vis the fundamentals of ethics? That's one question. And then there's Counsel Jackie Achan Okot, who says counsel should guide the client and maintain professionalism. If the client is dictatorial, in extreme cases, counsel may consider withdraw from the case rather than face embarrassment and lose the case ultimately, for which the client would still hold him or her responsible. And then again, Counsel Isaac Kabio says, isn't it the role of in-house counsel to collaborate when it comes to preparation of pleadings alongside external counsel? Or should it be limited to just a supervisory one? Again, alignment of roles. You hinted on that, so back to you, Counsel Patrick.
Okay. Okay, thank you. Again, ethics and strategy. At the back of our minds, ethics is at the core of our practice. It has existed for all this time because we must maintain a core of ethics. So essentially, I don't want to get into an academics debate here, but ethics are ethics. We know what is right and what is wrong. But the question is it wrong to use, when you're serving the interests of a client, is it wrong? I don't know. It depends on how we look, from which position you stand on some things. Is it wrong to delay a bank from getting money due to it for 5 years when you should have paid? Or is it a smart strategy for the client to maintain his property that would have essentially gone into, it's not foreclosure, but would have gone on to sell? Yes? So would it be wrong? Would you look at it as wrong if a person applied that delay tactic? I think it depends on the outcome. It depends on the outcome. If the parties eventually settle their case, I think then the strategy is positive. Okay? If the parties fail to settle their case, now of course somebody will say, but supposing it's a strategy, it's a strategy adopted to delay, and it is maybe a peasant against a rich man, and the rich man is, there are those situations I anticipate people asking. At the end of the day, I think it comes down to the moral compass of counsel handling the matter and what they envision to be their values and their ethics. My perspective was from commercial practice, okay, as a commercial transactions lawyer. So you may not transplant the same mindset to maybe a land transaction lawyer in a suit over a chibanja. The ethics there may be a little more nuanced as compared to the situation. So I think it's a question of having values and ensuring that as long as we're not doing something illegal, then I believe it may be acceptable to proceed a certain way, as long as it's not illegal. Okay? If it is a legal way and it's being done through the facets of the law, then counsel gets his stripes for thinking outside the box on how to get remedy for their client. You can't take it personally. It is strategy, and that's why we are lawyers. Okay? In regard to okay, so the question was ethics strategy. The second from Isaac, I think it was a comment on professionalism. And then the third question was on preparation of pleadings. Question of external counsel vis-a-vis in-house counsel on what roles they play. I think the roles keep shifting and the demands on in-house counsel have also changed. But essentially, the traditional sense was in-house counsel used to give the instructions to external counsel and leave external counsel to direct on how the suit should be managed. Okay? Now, in-house counsel, of course, have a task to have a more proactive role, to follow up on cases, to ensure that things are done right. I think there is just a need not to overstep the supervisory role. I think you need to leave external counsel to play their orchestra according to their choice. If they have chosen a strategy and you believe in them as counsel, you just have to let them do their thing and just only come in to help to provide what they need. If they need you to swear, to execute documents, provide the evidence, then give it to them. It becomes hard when you have too much input from in-house counsel. It sometimes derails the strategy for external counsel. But it's also not to say sometimes external counsel has a word of experience on certain matters and insight. They have litigated maybe 10 cases before this person handles the case. So sometimes there's also that wealth of knowledge. But it would be helpful on how it is put across. Okay? If it's done professionally, I guess there's no problem. Because if somebody tells you we have done 20 cases, and from my perspective, this is how best the strategy would work, with that kind of evidence and insight, yes. If counsel is not aware of a position, an in-house counsel who is not AI-oriented but grounded in law knows, it is okay. Okay? Okay? Because like you say, we may have our generation which just reads what is available and does not know what is off the books. Not all our cases are in court. Not everything is online. So some people have the benefit of knowledge because of their access. So yeah, in other fora, you'll find in-house counsel maybe have their fora where they discuss these things and they may have an insight that we may not as external counsel. So I think it comes down to how in-house counsel tackles that. So I think that covers the questions. Thank you.
So much. Final applause. Thank you for asking questions. Thank you for the comments, but also picking interest. When you have the opportunity, you utilize it. And don't be shy. Eh? We don't want the young versus the old. It's cross-mentorship. It's a cross-mentorship, kind of. The young can teach the old can teach the young, and the young and the old can still learn together. Yes, so that should be the approach and the spirit. Now allow me hand the mic to finally our next session moderator, that is Stuart, Councillor Stuart, Mr. Mentor. Yes, thank you for being patient, but I hope that this session was of great value.
Thank you so much. It's 5 minutes past midday. Good afternoon. Yeah, you're a great audience. Nice to have you. The young versus the old. I will start with a comment that one of my colleagues made, that lawyers should worry less about competing with AI or technology and more on actually enhancing it as a tool in their practice. So it's important that whether you're young or old, but AI is here to stay with us. We must embrace it. But as Patrick has emphasized, you must have knowledge. You must be very well grounded for you to be able to deal with AI. So our next session, without wasting time, it's opportunities and challenges in commercial and corporate law practice. and we shall delve into perspectives from the commercial court and private practice. I'm privileged to have two panelists, Mr. Patrick. I failed to mention his name. I guess he will mention it better than me. But on the panel, it's Mr. Patrick. For some of us who might not know Patrick, he's Patrick is the managing partner at Paul Byarhanga Advocates. Patrick brings a vast wealth of experience, having played an advisory role on a wide variety of commercial transactions. He has a deep understanding of the legal and regulatory challenges faced by Ghanaian businesses and law firms servicing them. Patrick holds a bachelor's degree from University of Dar es Salaam, a postgraduate diploma from LDC, and he also holds an LLM from Makerere University, and he also happens to have attained a postgraduate qualification in copyright from the prestigious Harvard Law School. Then another speaker we have on board is Yusuf B. Kanyike. Yusuf is he works with Katz Advocates, and he has been at it for the last 17 years, and he has been at it doing commercial and corporate law practice, more with litigation. Those are our panelists. I will ask them to just mention one word, one fun fact about themselves that we actually do not know about them, that no one knows about them in this room. Let me start with you, Patrick. Yeah, that no one knows about you in this room.
That's a very interesting question. I'm one of those people who sees the world in such a way that I'm trying to be politically correct, but one fun fact, no, I love as a black person, I'm one of the few who loves the orchestra. Thank you.
Thank you.
Good afternoon, colleagues. I think, as they indicated, Yusuf is my name, working with Katz. Our Stuart has ambushed us, and it's a very, very hard area. But one of the things I think that people don't, you know, these people who they call the silent banners. I think I would call myself that. I think I'm not known in a lot of space, but when we meet on one-to-one, that is when you get the true colors of Yusuf.
Thank you, Yusuf. Thank you. Hopefully you won't be playing the card of silent banner on this discussion. I guess let's take it from there, and we shall just get straight into the conversation. We shall use the next 1 hour almost so in trying to discuss the opportunities and challenges in the commercial and corporate world. It's going to be a question and answer approach, and it's a discussion, and after all, you will keep on putting your comments in the chat section, or you can, we shall give you an opportunity to raise questions. I forgot to introduce myself. My name is Musimenta Stewart. I work with S&L Advocates. Thank you. I'm going to start with you, Patrick. We sit here in the corporate and commercial spaces and have conversations, discuss. The question I want to put to you first is, there are so many emerging areas in the corporate and commercial world. And for Uganda, for the case of Uganda, we need to know from you, what are those evolving areas of commercial and corporate law in Uganda that are significant, that give us significant opportunities where lawyers can actually concentrate and specialize to be able to make it under that space. Thank you, Patrick.
Okay. Well, that question is one that is very, very interesting in the sense that in this room, I think it is. I hope the young lawyers are the ones listening out there. But commercial practice is evolving fast. I mean, of course, we are aware of AI coming into play, but also we know that Uganda travels at its own pace. It's not as fast as as the first world. But essentially, areas of focus that people need to start perhaps polishing their skills, I would say areas of data protection. We have a lot of litigation coming up in that area, data protection areas, because big data in the 21st century, the most commercially viable commodity for the 21st century is data. For those of us who don't know, it is data, okay? People's information, the information that NIRA has, the information that NITA has, the information that UBL has on its customers, that is what is commercially traded. The information Facebook has on the Ugandan users. So for me, I think data protection is a key area people need to look at. Uganda has moved to have a law in place, which is in place, and we have actually seen litigation start to come out in those areas. I think we have seen the data ombudsman? Okay, the data protection office, I think, which is comprised under, is it NITA? Yes, under NITA. They have started dealing with a number of cases where people being taken there on complaints of misuse of people's data. We have Safe Border has been before the office. We have seen, I think, of a data breach. We have seen the Uganda Securities Commission also, USE, Uganda Securities Exchange, has also appeared before it for basically on data questions. So I think data and how you use it in this country is becoming a core area for lawyers to get appraised on. Of course, for companies, the large companies, we hear of things like carbon credits. We're talking about ESG. Yeah. Do we know what ESG is? Yes. Yeah. Environment, social, and? Okay, for those in-house counsel, of course, environment, social, and governance issues are also arising, which we must be apprised of. So people in the corporate space, these are things that you're talking about. Everywhere you go, you'll hear them talking about ESG. Okay, so young lawyers and people, and we in the corporate space need to have an idea about this. Of course, these are things that are rising due to climate change. I do know that Uganda, essentially there are discussions of having a carbon credit exchange, like interface that will be like USE. So those are things we need to understand. How do you trade credit? I mean, how do you trade carbon credits and get paid for them? Okay? Do we understand that space? Do we know what it means? They're telling people we are planting trees. People in Uganda plant trees to sell the trees. But now people are being told, don't cut trees, keep them, and then we are willing to pay you at this rate for this number of acre of trees. People are making money out there, and it's big money. You have a forest, and you're getting paid $100,000 a year to keep the forest, okay, because it's on a certain acreage. So we as lawyers need to understand this space so that we can advise our clients who are going to be the forest owners and the people who own these green spaces. So those are areas that we also need to go into. Of course, we have talked about AI regulation, for people so that you don't miss out on this. People are talking about AI, but even Uganda, we haven't even started this conversation on how we regulate this space, okay? Because we are automating so many things. We are on ICMIS, we are on all these other things, okay? What are the data protection issues there? And then how do we regulate these tasks which are not repetitive? Before you used to go to a clerk to stamp. Now we have, it's online, the registrar's signature and all these things. How are we regulating these spaces? What are the rules? Yeah. What are the rules of the game in using AI? So that is an area that also comes in. Of course, competition. We have big players in the Ugandan market. We have MTN, Airtel. What about the small players? Okay, so consumer protection rights have come into focus. We have competition has also started to arise. And I think, was it 2 days ago, Justice Mubiru made a good judgment in a nuance area. We haven't yet gotten to the bottom of it. It's a case of MTN against, I think, VAS Garage Limited, something like that. So in that space, we have, it's starting to evolve, anti-competition law. How far can these big players, shield themselves from competition from people who are coming up with creative or third-party products which run on their platforms? Okay, these are areas which we need to actually start, getting a grasp of, because we have the law. Now the question is, how do we implement this law, and are we taking these people? I mean, are we holding the big players in the sugar industry, in the telecom industry, in the energy industry, the mining sector? Are we holding them to account because of size? So off cuff, I don't know if that raises a few areas that we can start to have a discussion on. Now, of course, people will talk about the gig economy. There are lots of things. These people who are doing online advertising, the Jumia's online companies, everything is going online now, People can buy things online and not go to Chikubo. Things are happening online, and it's the border people who understand this economy because they do the deliveries. So the question is, how are we preparing to regulate, to advise URA? How are they going to tax these people? Yeah? How are we going to do it? 1. 2, what are the rules they play by? Where should they register? What happens to a payment you make from your phone or your bank? How is the withholding tax going to be done? So there are lots of these things that we need to start having discussions around, and I think there are opportunities for we lawyers and also young and upcoming lawyers. Again, it goes back to how much you know and if you can create a niche in this area. So I don't know if that is a short expose on that. Thank you.
Thank you, Patrick. Maybe you can mention something small on fintech.
I skipped fintech on purpose because when you talk about when you talk about new areas, everyone thinks fintech is new. Fintech is old. It's been around for the last almost 100 years now. So fintechs are not really new. I know there are online banks and there are new places coming in, new players coming in, but I think they still fall within the space I'm talking about because they need to be regulated. So I don't want to make them appear like they are totally new area for people to focus. They've been there. It's just a question of how to advise them and to play according to the rules that we set as a country and as lawyers. Thank you.
Thank you, Patrick. Yusuf, my next question goes to you. And as Patrick has ably discussed the new areas, and you clearly know that we have a specialized court, which is the commercial division of the High Court, to handle these disputes, especially when they get to that level. Do you think the establishment of the commercial division has created more opportunities for lawyers, and maybe do we need more special attention to these new areas that are developing in addition to what commercial court is currently doing, or it's actually it's enough for it to also handle these new areas that Patrick has been talking about? Thank you.
Thank you, Stuart. When we look at the issue of the establishment and operation of the commercial court, briefly, just to give an insight of commercial court, before the establishment of the commercial court, we had traders and the business community had lots of disputes. Okay, their disputes would be handled in these formal or civil courts. So they felt that disputes probably would take a lot of time to be concluded, and so there was a lot of lobbying to have a specialized unit dealing with commercial disputes. They felt that these ordinary judges in the civil, in the land, don't appreciate their problems. They said, okay, I think I need someone who can understand me. I need someone who can understand the business. I need someone who can really relate that when it comes to money. Money, there's value for money. At the end of the day, they felt that there were lots of delays in these formal courts. So the business community did a lot of lobbying, and as a result, we had the enactment of the commercial court. The commercial court was set up in 1996. I think 1996, that is 29 years ago. I don't know. I think we can, all of you reflect, where were you 29 years ago? 29 years, that was in 1996 when this court was set up. And specifically, as I said, it was set up as a result of lobbying from the business community. Previously, before the setup of this court, currently the court has 7 judges, and there are 3 registrars running the court. So in terms of specifically when you look at the opportunities at the level of commercial court, we've had a lot of improved case management. So previously, before the establishment of the court, on average, cases would take about 5 to about 7 years. So because of these delays, with the establishment of the court, this period was drastically cut from the 5 years, and cases took about 12 to 18 months to complete. So case would be completed within 1 year to 1.5 years. And this was really a very big turning point on the part of the traders or the business community. Then the other area I think that we need to look at in terms of opportunity is, I think, what you refer to as ADR, Alternative Dispute Resolution. One of the courts, I think, when you look at the commercial court, was the pioneer of ADR when you look at other courts when you mirror it. So ADR started off with the commercial court, and the underlying reason why we had ADR was that they wanted to reduce, we had a lot of case backlog, and because of these case backlogs, lots of monies for traders, I think, were tied. When you look at the statistics at the, I think as of 2024, they said about 85 trillion shillings tied up at the commercial court. So when you tie up in those disputes 85 million shillings, what was our budget, if I may interrupt? Anyone who knows our budget for 2025? I think as lawyers, you need, these are the areas you need to look at and say the money is here. What's our budget? Uganda's budget. Yeah? Yes? No idea? It was about 49 trillion. So, okay, then what about the new budget? I think the projections. Yes? The new budget is about 72. So if commercial court alone, when you look at the disputes, 85 trillion, that's basically our budget. It's tied commercial court. Because when you look at the monies that disputes, because the bulk of this economy is controlled by the business community. That's where the money is. So with ADR, they came up to look at a quick mechanism of resolving these disputes through mediation, through arbitration. So that was, with the establishment of this court, that was another opportunity that was created. And it, from the commercial court, then it spread to other divisions. So in terms of, then the other opportunity that when we could look at with the establishment of the court is that it has become a model court for judicial reforms, just not only in Uganda, but the region as a whole. So a number of areas like reforms, when you look at, I think, ICMIS, it started off with commercial court. Issues to do with, I think I already told you, ADR, like arbitration, mediation. The commercial court has largely been used as a vehicle for a number of judicial reforms in terms of, that is where they do most of their test studies, and when they realize that it's successful, then it's rolled out in other sectors. And as you note, not only for Uganda, but even other countries come here. There are a number of our neighbors in Kenya, in Tanzania, in Rwanda. They come to the commercial court to see the success that they have been able to register. That notwithstanding, but those are challenges. Even, you know, when someone realizes that this is a very efficient person, at the end of the day, everyone wants to run to that person. At the end of the day, you realize now this court also is struggling with a number of things because people realize this is a very effective court. When you file there, you matter, you'd have it disposed in 1 to 2 years. Now, we find people having land disputes, people having civil disputes, they find some connotation, some commercial connotations because they want to file it in the commercial court. So with this again now, that's why you realize that now they have started having issues to do with now backlog and other issues which previously they did not have. Then the other, I think, opportunity that we've had in the commercial court is that it has boosted investor confidence. Why have investors come up here? You know, when they have a dispute, we have a robust system that would address their disputes. So it has, in a way, contributed in that sector. Then I think briefly, time is not our ally, you would allow me to skip to, in terms of areas that would need further specialization. I think when you look at the commercial court, which areas would need further specializations so that we have more efficiency and in this court. So when it comes to areas, I think my colleague has already pointed them out. There are areas like technology and intellectual property. So I think technology, these are the new lawyers, I think the Gen Z lawyers, they can tell us that within the commercial court, we could probably have more specialized divisions. And with a specialized division, they'll be able to address some of these emerging areas. We'll find the judge, some of the judicial officers, probably who are trained in a particular area, and they're probably not able to appreciate issues to do with maybe, let me just use broadly, maybe intellectual property, maybe issues to do with technology, issues to do with fintech, like they pointed out. So we may need within the commercial court to have more specialized divisions, and with the specialized divisions or specialized units, we might have training for judicial officers specifically. I think when you look at, we have specialized courts in other areas. So when you have specialization in areas that I was pointing out, I said technology and intellectual property, then the other area would look at is in banking and finance. The bulk of the disputes, I think, would in the commercial court have some connotation with the banking and finance. When we talk about banking and finance, we don't typically look at only banks. Okay, we look at other even non-banking institutions, because there are a number of, there's tier 1, there are microfinance deposit-taking institutions, you have these money lenders, you have a number of things. So that is another area. I think when you look at the cause list of the commercial court, you realize the bulk of the cases, I think I would say maybe probably half, you realize they involve financial institutions in one way or the other. So we may need to look into this area that would it probably, can you have maybe a separate unit? You might find maybe they may have to dedicate 1 or 2 judges just to handle financial matters. I think when we move to specialization, at the end of the day, would have faster disposal of the cases. Second, I think we would have also some degree of certainty when it comes to precedence. I think the challenge as practitioners that we have is you find we don't have standardized precedence. This judge decides this way, the other one decides the other way. But it's very hard if you have 2 or 3 judges handling only, say, banking, or those handling technology or intellectual property, having case conflicting decisions. Then the third area probably that would need to look in terms of that would require is, I think, what you call construction, construction and public-private partnership. When you look at construction, there are a number of government projects that are going on. Issues you look at, and these projects really involve big sums of money. You look at areas like, I think, construction, like look at roads, you look at maybe, say, doing construction of dams, a number of projects that are going on. So with the public-private partnership, I think we need a unit that would deal with those emerging areas, because So issues to do with FIDI contracts comes in, and those templates I think would be used. So these are some of the areas. I think the last one would be insolvency and corporate restructuring. That's also another area. My colleague Patrick pointed out other areas that we need really to have an insight when it comes to commercial court. But the proposal would be we should not have a separate, say, division, because at the end of the day, you can't have a division for each unit or for each new area that emerges. But within the court, you can create division that, and you allocate judges, you go and have them trained in those particular areas. So briefly that, let me hand over maybe to the moderator. Briefly that touches that area.
Thank you so much, Yusuf. A round of applause for that first thing. What I get from Yusuf when he's talking, you can actually see money in his head, in his words, because you can't tell if he, from his statistics, 85 trillion is stuck at that division of the High Court, then that's where the money is, and we need to maybe try to look at these new areas that are developing and be part of the 85 trillion that is at stake. Patrick, let's talk about when Yusuf talks about that court, commercial court. At times one might think, do I really need to end up in that court for any dispute regarding anything commercial? Do I need to end up in that court? So on the advisory bit of it, how is the increasing complexity of these commercial matters? Is it creating opportunities for lawyers practicing under this limb? And does it make any business sense to have this complexity in commercial matters that we need, as lawyers, we need to take it up and maybe not end up at court and maybe deal with it at the advisory stage? And maybe the legal risks which are involved, how can we be able to proactively deal with them when we are dealing with the advisory bit of it before we actually go to commercial court? Thank you.
Okay, that's an action-packed question. Our attempt to dissect it. Does it create opportunities for we legal practitioners? I think yes, it does. We'll take note that we've had recently an update of the commercial laws on our books. So we have what appears to be a robust reappraisal of the commercial transaction space. So a lot of opportunities have actually been created by that space. We have seen the new areas that ideally have been opened up by the various laws that have been enacted. In regards to the opportunities being created for lawyers, definitely. Yusuf has just talked about the fact that there is a commercial division and the judge, it has 7 judges. Now, of course, the question is, do these 7 judges have the expertise to address the bevy of commercial practice areas that have been opened up? That's a question the judges themselves can answer. I don't know if that is a consideration that is made in their appointment. You'll notice the commercial court has a new influx of judges. The question is, what expertise do they bring to the court? I am not approved. Do you know? It would have been nice to know what expertise is there, and we have the discussion with that knowledge. But honestly, it seems to be very well guarded information. I have no idea what the skill set that the judges at the commercial court at this juncture bring. Maybe ULS needs to start giving us a portfolio, a background of our very respected judges, so that we understand what are their niche areas of practice. But anyway, that aside, for we practitioners, of course, it opens up a lot of areas. We just had a discussion here earlier when I mentioned that you can see that we are now starting to explore new areas of practice which have not been on our books, such as the the Competition Act. Under the Competition Act 2023, we have seen people exploiting that. So the question is, how many of us are competent as competition law practitioners? Do we understand the nuance abilities under the law? Do we understand the nooks and crannies there? So we need to see people become experts in that area. We discussed the fact that 2 days ago there was a judgment which we are still dissecting by Justice Mubiru. I think he's one of the stellar judges we have on creating jurisprudence. So he's creating jurisprudence that is not native to Uganda as yet. These are new areas that we are exploring. And perhaps this is just one of the cases out of a huge backlog that is bringing the question of competition, fair competition, and is actually being adjudicated by the court. So there will be a question, is the court avoiding some of these questions that are being raised by legal practitioners? I don't know. But that shows that there are opportunities for us to actually litigate in the commercial court and challenge these new practice areas. We talked about data protection and the number of suits that have been. I haven't heard of a suit yet. Does anyone know of a suit on data protection out there? I want to believe I only know the tribunal, you know? Yes. Oh, we have 2 mics, sorry.
Thank you. My name is Kiega Hatwib. I was just emphasizing the case you just cited by Justice Mubiru of VAS Garage versus MTN has a component of data protection and the intellectual property related to data protection and databases. So if you interest yourself in it, you are able to answer your questions. Thank you.
Yes, apologies. I haven't digested it wholesomely, but I do know the decision is there, and those are the questions raised. And that is only because it was brought out 2 days ago. So apologies for that. But I'm certain when we get into the intricacies, we shall unearth those places. Now we have questions, for example, AI, which I know some of us are interested in. When you look at AI, there are questions of AI and intellectual property also coming, because we know the traditional intellectual property. We as practitioners, we have that traditional sense of IP. But now we have a question. For example, if someone asked me now, what happens if I go on an AI app and tell it to create for me submissions, okay? And then I use those submissions. Who owns the rights to those submissions? Is it I who prompted the AI to give me the submissions? Is it the AI, the owners of the AI, or is it, you know, IP of the person who owns the website or wherever I got it from? So there are those questions of who owns these things, and these are areas legal practitioners, I think, one, we need the law to evolve, and these are questions that are being asked. Who owns this IP? You've heard of art that is generated online. Who owns it? All these things, when you take a piece that is generated by AI and you use it in your work, do you need to reference it and say AI generated? Do you have to put a footnote and say this was picked from AI? Okay? And somehow AI is unique. Whenever you lift something from AI, it leaves the mark. You can tell, by the way, for those of you who don't know, there's always a mark that this has been lifted from AI. You may not know how to say it, but it will be seen, okay? Especially if you're using it for academic thesis, you don't want to embarrass yourself. So please avoid picking large chunks and just putting them in your work. It will be embarrassing. So there are those questions. So there are these areas that are being explored. We talked about online marketing, okay? We have seen in Uganda, we have so many influencers, okay? Yeah, the other day there was a trending, this was IP, of course, there was that trending thing of Bebe Cool and I think the comedy thing, Comedy Center, Alex Muhanji, yes. Those are areas where we are starting to interrogate IP at a more, you know, at a more sophisticated level, not on the basics that we know. So people are actually starting to open that space. Now there are questions that arise. how much content is put online. Someone goes to the movie theater and records a certain portion. Does Century Cinemax have a cause of action when you go to and you record more than a minute of what you're watching? People are taking pictures all over the place and uploading them. Yeah? Do they have rights to these pictures? So there are lots of things that are actually being generated in our in our time that people have not asked the questions, and the questions are yet to be asked and are going to be asked because there are monetary implications. People are getting paid through, you know, these online apps. You know, I don't know how many followers you have. People are influencers. We may not know what influencers are until your son or daughter tells you that they want to be an influencer. But people are getting paid massive amounts of money for apparently being influencers online. Do we understand how this is monetized? How do we track that money? How do we get it? These are questions that people are litigating. I mean, that questions that need to be asked, and I believe our judges are going to have to answer because disputes are rising out of these things. Someone records a song and it's trending on TikTok. People are using the song. Who is paying the royalties? Nobody is asking TikTok for that revenue, and yet people are using this music on TikTok. I don't know, for those of you who have used this site, if you know it, sometimes you find the music you've put is not loud for a reason, because there's copyright infringement. But for us Ugandans, people are using anything. So I don't know if you have the time. For you who are litigators, these are areas you can take on TikTok. Okay. So I believe our judges are in for an interesting 21st century, because the Gen Zs are coming into practice, and these are the areas that we expect to start having a lot of litigation over, because people are coming up with concepts, people are creating new work that hasn't been traditional, everything is online, and of course the litigation is going to shift from the traditional modes and forms we know. The principles remain the same, but of course now we have to take it a step and a notch higher in order to litigate at that level. So I think opportunities are rife in the commercial court. The only question will remain, what are the competences of the court to handle these disputes? And are we also at the level to litigate at that level? If that sounds right, I don't know. Thank you.
Thank you, Patrick. For those who are asking for the decision, it's Vas Garage Limited versus MTN Uganda Limited, civil suit number 689 of 2022. The decision was by Justice Muiru last week. Personally, I can't talk about the decision since we were representing one of the parties. So that's why I've tried. we have since lodged a notice of appeal, and but thank you so much, Patrick. And colleagues, what you can see from the discussion of these two gentlemen is that we are trying to tell you about the new opportunities which are available, that can be available at your that you can try to get into and make it. There are so many areas, especially with I think with technology we have to deal with it, and these are the opportunities my colleagues are discussing. Yusuf, I know you've talked about arbitration, or you've talked about alternative dispute resolutions, but I need us to discuss how can we be able to leverage ADR mechanisms. How can they be cost effective in trying to resolve these commercial disputes, and does it in any way present opportunities present in this current growing commercial practice? How is it? Is it something that we can still invoke in trying to resolve these disputes? Thank you.
All right, thank you, Stuart. Maybe before I respond to the question, I would request my colleagues to allow me exercise my passion, and I'm going to know about my passion to answer the question. If I might allow me, I'm going to ask maybe one or two people. It's a very simple question. I think this session has to be interactive. It's not between me and Patrick. So if you have a dispute, and it's going to be at random, say with your wife or with your girlfriend, what would you do? You have there's a small dispute, or there's a dispute that have come up. So first, obviously. Say, yes, coming back late, someone has come back late, what would you do? Yes? Yes, your girlfriend or your wife has come back late, what would you do?
So the coming late being the dispute here, or? Anyway, I saw, I think, a video on X this week. Yes, and I don't know whether it was a husband or boyfriend, but it was late in the night. You could see around 3 or 4. The husband was sleeping. Then the would-be wife or girlfriend came, knocked on the door, actual bedroom window, and called him out, come and open the door. But of course, you know how women dress for those night events. So the husband, instead of opening the door, opened the window and then started recording her and asking questions of where are you coming from, how are you dressed. I think the man was not around, so she didn't expect. So she was surprised the guy was home. She started apologizing. I'm sorry. I won't do it again. I think she realized the decency and all that. So if it were me and she had come in at that point, first of all, I wouldn't record, but then I would want to understand what happens usually when I'm not around, because how it happened, it seemed to me like she wasn't expecting to be around, so she took advantage of that. So the question would be, what happens when I'm not around? Then how do you represent me out there? Because I'm married, I certainly must have discussed a few of those things, because either of us is a representation of the other outside there. Because I want to, have my image right there and probably have your image right there. So those are some things we need to discuss, such that we avoid such eventualities. So the questions would be really about how to approach the dispute, talk to them, see what's not happening and cover up, and see what to do in the circumstance, rather than put it in the space for people to judge. Yes.
So in short, we would have a conversation about what exactly happened. Last, maybe you have given a loan to your husband and he has failed to pay. What would you do? You've given him a loan. He says, well, things are not working out on my end. He has declined. Told him, I'm going to give me maybe 10 million. I'm going to pay it the following. The week becomes 2 weeks. It becomes 1 month. It becomes 10 years. No, let me say 2 years.
I leave it. Yes? I just forfeit it. Yeah.
She says she forfeits the money. And what am I trying to arrive at? The issue I'm trying to look at is, I've not had any of them, either him or her, telling would divorce. Okay? Have we had any divorce? We have had a dispute over this. So basically that lays foundation for ADR. If you have a dispute, the first line of mechanism to resolve a dispute is not running to court. You have had a dispute, because he has not indicated that what he would do is probably I would file a divorce. The other mechanism you're trying to trigger to resolve this dispute. So ADR basically is is an area probably that if you're looking at developments, I think there's a bill in the offing. Initially we had ADR which was compulsory, then they made it optional, then so there's a bill in the offing, I think, coming up in this area of ADR, and I think there is a center, those who are following events in ADR, are you aware of, I think there's a center which they're trying to put up in Gulu, to handle ADR matters. It would be more of let me say the central place to have this ADR mechanism. So, as practitioners, how can we leverage ADR at the end of the day to satisfy the clients, okay, and to offer solutions? As a lawyer, you represent a client. Whatever you do is for the client at the end of the day. It's not you as a lawyer. Client these days want more efficient and cost-effective solutions. And one of those avenues that we have is through ADR. So how can we leverage ADR as practitioners to the satisfaction of a client? So one of the areas we need to look at is in terms of, one, we need to position ADR as the first line of resolution of disputes, as a first line. So how can you have it as a first line as a practitioner? I think when you're doing a number of contracts, issues to do with commercial contracts, issues to do with the land agreements, let us have these provisions in these agreements, okay, as practitioners. Because at the end of the day, if we embrace ADR, I think it would probably cut across. So in a number of contracts, we need to embrace ADR as a first line of resolution of disputes. Two, the other leverage we would have is we need to also educate clients about ADR options and give them the pros of ADR. So in terms of pros, we would look at issues to do with faster resolution of disputes, issues to do with lower costs, issues to do with confidentiality. Just look at matrimonial causes or family disputes, okay? If there's a divorce, some of those things, parties would prefer to keep them confidential. But if you choose to go in litigation, everyone out there would know a lot of things within that home, a lot of that probably that you would not wish to spill in the public. So we need to educate about clients, about those ADR options. Then the other leverage as lawyers to be able to we can ride on is we need to get ADR accreditation, and also we need to probably also to join panels. As practitioners, we need to get training specifically tied to ADR. There are a number of institutes that offer these trainings. I think we need to look into this area critical. Then I think we can also look at the use of technology to facilitate dispute resolution. I think this is where especially the Gen Z where they come in. So if you have ADR, they cut costs on travel and the time probably you spend, because you'd probably have an online session to try and resolve the dispute if you have a mediator or you have an arbitrator. So it offers some degree of flexibility. At the end of the day, you could even agree, okay, can you have a session maybe at 7 p.m. when probably all parties have had their day, and which you can't have in this formal session. And you could also share probably success stories that would encourage other people. Obviously, if you have to share these stories, it has to be with the consent of the client. In terms of opportunities, there are a number of opportunities that we have in this area. Opportunities, it is another avenue for revenue stream. You look at it as an additional income coming in from ADR. Why do you look at it as a new revenue stream? So in terms of this other work probably that you're doing as a practitioner, you could also look at ADR to diversify basically practice among other things. So when you look at ADR, it could be probably, you could package it in a way maybe in terms of hourly rates or in terms of a flat rate if you have to handle a particular dispute. Then it also, the other opportunity that you have, it's a faster case. You'd have a faster case turnover, because unlike litigation, you'd have a case probably ending in court for about, on average, maybe 2 to 5 years. You could have a matter disposed of in ADR in a couple of weeks. So once disposed of in a couple of weeks, you're able to have probably handle other disputes. So at the end of the day, you'd have a higher turnover. The challenge you have as practitioners, we think you can only make money through the mainstream litigation, which is not necessarily true. And So through ADR, you probably may pay lower fees, but you handle a number of cases. So we need to look at that. We need to embrace ADR as well. Then it would also probably lead to increased access to justice, because ADR offers opportunities even to areas where we don't have formal courts. You could have ADR in those areas conducted, because courts, you can't have courts in each and every place. They are probably in particular areas. So you could increase this and go into, yes, maybe if I might complete, then maybe I could take a question. Then you could also consider professional development and recognition. That is getting certified as a mediator or arbitrator can open doors for you to probably sit on the panels or have cross-border commercial disputes, you can handle them, and regional opportunities. There are a number of opportunities in this area. We're just trying to hint on one or two because of time. I think, I don't know whether it would be an appropriate time, maybe moderator you can guide.
Yeah, we shall take questions in the last bit. Let's keep it for now. Sorry. It was a comment, okay.
I think my comment to ADR and embracing it is, I think it's simple. Lawyers are not embracing it because of the economics in it. Because all of us here, I'm sure most of the litigation matters we receive arising from contracts in one or the other have dispute clauses. And most of the dispute clauses actually advise ADR. And some even provide the centers for arbitration. But you find them, lawyers, find those very cases in court. So I think it's an issue of economics, and maybe this is where we need now to advise the people that protect the industry to make amends to the taxation rules and maybe include fees as far as arbitration is concerned. Because most lawyers go to court for the economics. They actually know they have no cause in court, but they can have it here, but they decide to go there. So it's really about the economy and the shortfalls in the remuneration rules.
Thank you. But one of the things I will mention, not so many years ago when I was still in school, I used to think, when I used to read cases by Patrick, Yusuf, where they have appeared, I used to get inspired that I should also handle cases that can be read about. But trust me, my boss usually tells me that my clients are interested in profits. They're interested in money, not precedents. And I want to tell you that I think you find 90% of the cases I handle, they have always been concluded in mediation, in arbitration, actually just mediation. And at the end of the day, I feel like it's not an academic topic. ADR is not an academic topic. It actually works. I'm so interested in concluding a matter than litigating it. Now, the few cases I've handled, I'm very sure that I'm interested in mediating a matter and conclude it rather than spend a year in litigation. So at times, it also depends on the type of a lawyer you are. Why are you interested in costs in court? Why are you interested in costs? When you can be able to recover $1 billion in 3 months rather than recovering it in 2 years. So ADR is very, just give it a shot and try to utilize it. You will not, next year when we come back for this conversation, you will be the champion of mediation and those ADR mechanisms. Patrick, I see it's 1 p.m. We have a few minutes to conclude this session. But Patrick, I wanted you to talk about the developing legal framework. You've talked about so many opportunities, you and Yusuf, regarding the commercial law practice. How is the legal framework? Do we need changes? Do we need reforms? How is it?
It's a very interesting question. Do we need reforms? Definitely there will always be a need for reforms, but maybe my comment comes first that we must take note that the legal framework has just, for the commercial laws, has just recently been beefed up we have a number of laws that have been enacted in the recent past. I talked about, of course, the Competition Act. We have the Insolvency Act, which has been amended profusely to provide for quite a number of new things. You have the Companies Act has also been amended severally. So over the past, those were amended, I think, between 2022 and 2023. So I don't know if in Uganda it is now the time to start asking for reforms. But definitely, if you look at the global, if you're to look at the fast-paced world, definitely we are always a step behind. So when you look at that, you may say our laws are still commercial practitioners. They still need an upgrade to provide for new things. But appreciating where we are, I think they provide for many new things that we haven't even started to utilize. Okay, so I think, I don't know if I say, because I'm being practical, if I say we amend the laws, we won't do it in the next, I don't know, 6 years. How long does it take to amend the law in Uganda? 10 years. So if we are to be realistic, we expect an amendment in the next 6-7 years. So I think where my practice, the way we practice, where there are new better practices that have been brought to the fore, I think it is us practice and not to wait for the law to be amended, because thank you. I believe that most of these things will come out of usage. Where we think there needs to be an improvement, we may have to either litigate our way to that improvement or put it in our contracts. Okay, if you find there's a position that is new, definitely as commercial practitioners, then we need to adopt it, and probably it will come to play through usage. We see, for example, if you're in banking, the banks now, whenever you're using checks, and you're withdrawing certain amounts, you receive a phone call, okay, to confirm whether this amount should or can be withdrawn. It's not in the law, okay, but for me, I'm arguing it's now part of usage. So it is, in essence, it has become law. If you're waiting for the consumer protection guidelines of BOU to be amended for that to be added, or for the Financial Institution Act to be amended to provide for that, it may take forever. But it's now known practice that if you go to a bank and you are transacting within certain limits, and you're probably co-signatories on the account, the other party will be called, the person who's not in the bank. You're either together or the other party will get a phone call, right? So if that is the practice, then I think usage will become the way some of these things are going to be adopted. Talking about the number of changes that have been made to our tax laws to provide for, to promote venture capital financing. I didn't talk about VCs, but we have benefits for people who are interested in that area of practice. Venture capital is being promoted in Uganda, and even the tax laws have been amended to promote that. So for you who are looking for quick money from South Africa, Europe, the US, it's quite an interesting area to be practicing now. So the laws have been made more tenable in that regard. The good thing is with the tax laws, almost every other year we amend, because it is a practical and necessary position. Every year they're being amended and additions made. But for our commercial laws, that's a challenge, because when we amended in 22-23, we provided for company law, beneficial owners, and a few things were made. Now, 2-3 years from now, there are new things that ought to be added, but probably we'll have to wait a decade for that to happen. So in a decade, we'll be putting into our law things that were supposed to be there in 2025, and we'll be putting them in 2027. So it's quite a challenge, but I am certain as practitioners, we do it the way we do. When you learn something new, you adopt it in your contracts and in your practice, and hopefully other people start to do it. Where it's not, you litigate your way to it. And finally, if you can't, I think eventually we always iron ourselves out as we go ahead. Thank you.
Thank you so much. I see time, it's 6 minutes past 1. I will request the thank you so much. I will request to use more 10 minutes of your time to be able to conclude this session. Sorry for interrupting with your lunch. Yusuf, let's talk about a bit of challenges because we've been talking about opportunities. Let's talk about a bit of challenges. With our specialized commercial court, how is the enforcement of these judgments at the end of the day? Talk about briefly about enforcement of judgments. Is it a challenge or it's me thinking out loud?
Thank you. When you look at the issues of enforcing judgments, it's not enough as a practitioner to say that you have won a case, because that does not deliver results to your client. Your client does not want you only to stop at winning. After winning, what happens? Okay, so that goes through the issue what you call execution. It's equivalent to saying you have been dating someone for 10 years and that person is not yours, even if you have dated for 10, until that person says, I do. Okay, that is when now you're certain. So it's not enough really to say I've won. You need to go ahead and execute. But when it comes to execution, particularly looking at the commercial court, I will not take you through the history of what happened, because in light of time, the issue of the execution division and others, I will not delve into that. But the number of challenges when it comes to enforcement of a commercial court judgment. One of the challenges we have is delays in execution proceedings. Even after when judgment has been pronounced, there are mechanisms, or there are steps that you need to take to be able to realize the fruits of your judgment. And to be able to realize those fruits, you need to go through the execution process, which is really, I would say it's a bit slow because of a number of reasons, and one of them could be the backlogs. So there are delays. Then the other one is, the other challenge is you find a data who's evading enforcement. And what do they normally do? They probably hide property or register them in names of third parties, or they relocate to avoid service. So you're dealing with very shady or crafty debtors. Then we also have a challenge of inadequate asset disclosure mechanisms. In Uganda, we find some people we don't have a compulsory mechanism to make people reveal their assets. So we don't have a robust system where you can easily track someone's asset to be able to satisfy or fulfill the judgment. Then there are lawyers, as a practice, the moment they lose a case, they just put in an appeal. And why? Because they want to probably avoid or delay. But it's used as a common tactic to delay, even when they know there's no merit. I don't know where you picked this habit in Uganda. The moment a lawyer loses, the first step is put in a notice of appeal, put in a letter requesting for proceedings. Then the third one, if probably you attempt to execute, then apply for so these are things at the end of the day that would end up frustrating the other party. So even you realize, I think as practitioners, we also need to be able to advise our clients. This is not a good case. This is, I think, we need to explore settling this kind of matter. So besides that, then we also have the issue of cost of enforcement of a judgment. You realize if it is a small claim, you're looking at a claim of about maybe 5-10 million. Okay, how much are you going to pay to the bailiff? How much? There is that unauthorized facilitation. I need to get clearance from this. You need to get clearance from that. You need, at the end of the day, you're using money. So someone weighs in and say, well, if I'm to pay
10 million or 20 million to recover 10 million. Does it make commercial sense? So, and then the other challenge, I think, is largely on the part of the process. If you have, even if you have gone through the process of execution, you need to get those clearance from RDCs, you need to get clearance from the DPs. So it's as if they're subjecting courts, the decree and the judgment to further scrutiny, to say, okay, this one I'll enforce, this one I will not. So at the end of the day, you realize your clients end up being frustrated, having even gone through the right channels. And there are a number of reforms probably which we might have to consider in this area. And some of the reforms we may need to look at issues to do. In fact, before we go to the reforms, another area you need to look at, these bailiffs at the end of the day, at times they don't act professionally. You engage a bailiff to go and execute. Before you know it all, the other side is paying the bailiff. Because, so at the end of the day, you become really frustrated. You have hired a bailiff to execute, then the other party is paying them not to execute. So we need to regulate and professionalize our court bailiffs. Then I think we also need to look into areas of, we need to enhance an asset disclosure mechanism, especially for the debtors. Okay, we need to have mandatory measures for someone to be able to, for debtors to be able to disclose their properties. Then we also need to strengthen cross-border enforcement. I think I've heard of foreign judgments. It's difficult to enforce foreign judgment unless you have a reciprocal agreement with that country. So we need to look into those areas, because if countries where you don't have reciprocal mechanism, can you probably enter into agreements? And also we need to address a number of introduce alternative enforcement mechanism, that is mediation during execution. Mediation does not end at the level of during trial. Even at appeal, I think for those of you who have been to the Court of Appeal, they also encourage mediation before the appeal. So we need to open up, at the end of the day, it may be worth it. It's okay, let's forego this kind of money, let us forego interest, okay, you pay. At the end of the day, some of these debtors, they just want probably come up with a scheme of payment. So I think in light of time, allow me probably to end at that stage.
Thank you so much, Yusuf. Justice Mubiru was recently transferred from the commercial division, and I think his time at that court has been a good time for us litigants at that court. And I'm very sure, for me, if you bring your stay of execution application, it is a money decree, you are going to give me some money. So I feel like that's no longer a problem at that division. After all, Mubiru has given us so very many decisions on the aspect of money decrees. So I feel like the lawyers are using it to prolong litigation. At the end of the day, I think Justice Mubiru has been a proactive judge, that we've been able to benefit from some of his decisions. Then secondly, I think, and when Yusuf is talking, you realize that now ADR comes back. You must embrace ADR mechanisms, because that's how you are going to be able to unlock the monies that are stuck at that court. Lastly, let's hear from Patrick on, I want you to talk about competition and pricing measures when it comes to law firms when they are taking on these disputes. We are privileged that you are the managing partner of the law firm where you come from. Competition and pricing pressures from other law firms. A law firm will handle this matter at a particular amount, another one will handle it at this amount. How will you be able now to keep on being relevant to the clients, and you are able to get on as many clients as possible? How are you dealing with that? Thank you.
That's a very that question is quite one I think you need to bring on the whole house on. But I think as practitioners, of course the numbers of lawyers have increased, the competition is stiff, but there is also a question of how much work is out there in truth. the question of how much work is out there, and then the ability of the clients to pay the fees that we are billing. Now, you'll find in our countries, surprisingly, you'll find there's a question of the big firms, yes, which have a monopoly over certain business, and we as practitioners have not come in to curtail monopolies. So as this competition law has come out, perhaps those are things we need to talk at. Who has, for example, if a large bank is a large bank has business and certain lawyers have been on their call for the past 20 years, is that fair to the other lawyers? Is it? As practitioners, is that fair? Shouldn't we have a regulation that says perhaps clients that retain lawyers need to have a turnover every 3 or so years? Wouldn't that be a fair position? Yeah. For example, accountants or auditors. Can a certain firm, can you have PKF as your auditors for more than 3 years? Yeah. Isn't there a certain period? There is a moratorium on how long they can be. So there is a turnover. So I think we also as practitioners, need to adopt that proactive mechanism so that this business can really turn over into other firms. Otherwise, we will stay with this notion of some people are more able than others, and yet some of this work is really not so prolific. For certain nuanced areas of practice, yes. But I'm not attacking anybody. I'm just saying those are conversations we need to start having. There are issues of, a certain person will draft a contract at 50,000 and another one will draft it at 1,000,000 shillings. That one I may not have a remedy to, because there are years of experience, exposure, there's class, there's quality, there are so many things that go into the billables, right? So for pricing, for clientele, I'll not talk about that. I'll restrict myself to the question of competition between firms. I think what we as legal practitioners need to have, one, we must maintain our standards as practitioners. Of late, even border men are discussing lawyers' issues and lawyers' pay. You cannot convince people that lawyers are supposed to be paid a certain way. And I think it comes from, one, we need to maintain standards of the quality of lawyers we have in this country. Should we accept lawyers to have law firms on arcades? I don't know. Those are things we need to look at. Should law counsel have certain standards thrust upon the profession so that the profession can maintain a certain outlook in order to raise certain bills? Those are questions we need to have. You find a law firm in a market. Is that correct? Is it right? When you travel to India, the competition is so stiff that people have a desk on a street. In India, you find so and so partner. The competition is that stiff that a person puts a desk on the street corner, and that is an advocate, and people go to them. Perhaps for them because of the population, but are we going down that route? Are we still going to be able to bill clients in the near future if we go down the route we have adopted? Is it still sensible for practitioners to start law firms after 3 years? Is it smart? Shouldn't we be looking at firms expanding, the turnover of law firms, opening and closing? Should it be so easy to open a law firm? Those are conversations we need to have, because it's a question about the profession. It's much bigger than just individual practitioners. We need to look at the profession as a whole, not to bar entrance, but to have a question of quality standards. Because now, when you have an open pool, we have all these, questions and issues arising. Because if you have a certain number of people who have practiced for a certain time, they have an appreciation of billables, there are certain things they will not do. Yes? And that will keep the standards at a certain level, so that people know when I enter a law firm, back in the day when we started practice, some of us anyway, you would hear when a client entered a firm, they would ask, you have to open a file, right? A filing fee or something. Or like a client would pay a certain deposit or something like that. Now, do they still do that? I don't know. But those are questions we need to have, because we have the standards we expect of an advocate. Do we have any? So for competition and pricing, I think that conversation as a society we need to have and agree that, you know what, as a society, these are our standards and we are going to uphold them across the board without fear or favor. It's not a question of age. It's not a question of means. It's a question of preserving the profession, for all of us. Otherwise, these gaps will continue to increase between the prolific lawyers, who will remain a few, and everybody else will fall in between, which will not be helpful to the profession, because that gap kills the profession as a whole. Okay? That will be my comment on that.
Thank you so much, Patrick. Before you leave that microphone, what is your concluding remarks to any corporate and commercial lawyer out there practicing the law? What is that one thing you can tell him or her?
Well, for a corporate and commercial practitioner, the rule is you get up, you step out, you dress up, and you step out and make that money. I think that's a summary. Thank you.
Yusuf. Remarks,
okay, my concluding remarks. As a corporate lawyer, corporate and commercial practicing lawyer, we need to be open to changes. The world is dynamic. Things are moving very fast. I think they indicated AI. So you need to be abreast with the changes. I think we need to move away from this traditional thing that things were done this way and they will be done that way. We need to be open to change. We need to be open to learning. Okay? And that's why I think probably ULS organizes such kind of trainings, because at the end of the day, the world is dynamic. Many things are changing and they are moving at a very fast speed. So that is probably my concluding remarks. We need to be open to learning and change, because the dynamics are ever evolving day in and day out. Thank you very much.
Thank you so much, Yusuf and Patrick. I thank you, the audience, both the online audience and physical audience. Thank you so much. I think we have learned one or two things from the panelists, and I don't know, are there questions, or we can? No, we are on people's lunch.
Thank you very much. I'm going to be very brief. Mr. Patrick and Mr. Yusuf, I'm so grateful for what you have shared. You talked about billing, and we should cut across and appreciate the new principles. So my question is, don't you think we should be talking about how we should be paying the young lawyers generally? Because logically speaking, I don't think we have a policy that regulates how we pay young lawyers. And I'm talking as a concerned citizen or representation of the young lawyers. Ideally, law firms, or majorly law firms, there is no structured policy or regulatory reform that emphasizes on the minimum standard of pay. Rather, we are given what? Peanuts. So don't you think we should leave the archaic mindset and think something like that? Thank you.
Thank you, Patrick. You can take it on.
What do you mean, Stuart? Anyway, that question is one that I was dreading, but it's okay. One, again, it goes back to the standards as a profession that we want to have. In a profession now where we are proliferated with firms on every corner, everywhere, the question is, do the young lawyers believe these firms have the ability to remunerate them at a desired level? It's a question that we have to put to ourselves. So there's a difference if we have certain standards in place to what a law firm should be, to what the staff in a law firm should be, and to what the remuneration in a law firm should be. That can be a standard put across the board. Where the profession has standards, it's easier to implement. Where the profession doesn't have, it becomes hard. Okay? So young lawyers, unfortunately, you are practicing in a time where we as a profession need to start having standards thrust upon us. And we say, that when you're running a law firm, the minimum number of people or lawyers should be this, junior, associate, this. Then when a person comes out to have a law firm, there will be certain benchmarks they have to meet. Is it hard for everybody to meet them? Probably. Is it good for the profession long term? I believe so. Because if that is not implemented, definitely a lot of things fall through the cracks. That's the hard truth. You will keep on saying that lawyers are paying you with internet and bundles, and it will stay that way. Okay? Unfortunately. Thank you.
So much. Okay, last question. My panel was on corporate and commercial, so those questions relating to payments.
I decided to make a comment on payment of young lawyers because I have been running a law firm for 24 years. My view is that if you are a young lawyer, make sure that you are worth paying the amount of money you want. You see, just because you have a law degree with first class or whatever class, with a diploma in legal practice, and you dress well, does not mean you deserve a good pay. My view and my experience is that every senior lawyer does not want to lose a potential, active, dedicated young lawyer. So if you make yourself that, you will actually be the one to determine what you are paid. Because there is something you add to the practice where you are working from. What is your contribution? Now, I know that we are having lunch, but I can say I can point out some few of the challenges that the young lawyers have, which have made them not to be paid highly. The first one is that the young lawyers, sometimes, some of them, maybe very few, maybe very many, but with my interaction, they don't know what is what we call KPIs. You need to know your key performance indicators. When you set out to work, what do you give? Do you come on time? Do you deliver the work? What is the quality of work? If those things are good, every lawyer will even borrow money to pay you. Secondly, there are people who are cheats. Cheats not because of money, but who cheat time. You find a young lawyer is very is always at work on time, but what does he do? Busy with the social media, and you say, please write to me for me submissions on remedies for damages, and the person you are presenting on Thursday, the person is not ready on Thursday. Things like that. There are many weaknesses, and as an individual young lawyer, I think you need to prove your worth. And if you are not getting what you deserve, it will be easy for you to go to another law practice where you can get better pay. You don't have to stay where you are. This is an open world. Thank you.
Thank you so much. I think I will hand over to Amolon.
Thank you so much, Ms. Mentor. Let's give Ms. Mentor and the panelists a round of applause. I think there's been a lot of takeaway, but also emerging opportunities, and I'm sure that we won't live the same. Life is about evolution, flexibility, innovating, and looking out for what is hot there. You know? So I think these are spaces that we are making use of. Please do register. Don't forget to register. There's a QR code. Looks like this. If you can't access one, go to the admin at the back. They'll be able to help you. For the online participants, there's been a request for you to rename yourselves using the names that you use at the Uganda Law Society admin details. So please kindly follow that. There was a question on if Uganda has a minimum wage rate set by law in Uganda, that is by Councillor Isaac Kabuye, and I think it's a debate that has been going on in terms of labor laws. I don't know how far we've gone. Question of young lawyer or old lawyer, it's always about, are you worth your pay? It doesn't matter sometimes the age, actually, that's what I've come to realize. So certain conversations are hard to swallow, but we thank council, senior council, for the wise share. Some things resonate, some you ponder individually. There are also adults who keep on phones forever. But I think most importantly is about you proving your worth, but also investing in yourself to make sure that it's not negotiable. You either can afford me or you cannot. Yes, because law is very demanding, right from demeanor, how you dress, how you appear, to investing in the books, advancement. Already you have the backlog of the 5 years technically, 4 at law school, and then the 1 at postgraduate. And then also expertise these days, mentorship. There used to be that requirement of, working under law firm for a year before you, go out there and spread your wings. These days, law firms are everywhere, so there's also cheap labor. And then AI is not helping it, isn't it? Clients are now coming with their submissions and pleadings for your stamps. But we live in interesting times. Dear panelists, thank you so much. Thank you, participants, both physical and online. Please don't disappear. Take your break. Register, please. Please register for your points, the 10 points. And then also for the physical participants, there'll be coupons at the back and directions to where you can have your lunch. I thank you for your patience, and let's be back by 2:15 at most. Thank you. Okay, if you remember very well, I can just refresh. The next item is criminal law in a changing world, and they'll be talking about modern practice and emerging realities. And I think our moderator is already here. She kept time while we're having lunch. She was gathering the energies within the room. And I think she is very ready. Miss Sylvia Namaweja Ebitu, the moderator for this afternoon, is super. So I don't know why the mic is going on strike. We left it here when we went for lunch. So it also wants to strike hunger or battery. Okay, I think let's give her a round of applause. Clap for her, gather energy. It's not easy to keep the audience awake in the afternoon, so make sure you pinch.
Thank you very much. Thank you, participants here who are attending physically and even our audience online. Thank you so much for taking the time to be part of this litigation training. I'm very happy to say that this afternoon we are discussing an area of the law that is very dear to my heart, that is criminal law practice. And our topic is criminal law in a changing world, the modern practice and emerging realities. So as I have been introduced, my name is Namaweja Sylvia Ebitu. I'm a practitioner with Asimwe Namaweja and Company Advocates. I have a lot of bias or practice in criminal law. I've been a practitioner in criminal law since about 2013, with particular interest in defending our Ugandans in different courts, International Crimes Division, High Court, and even magistrate courts. So I'm happy that criminal law has been given a slot, and I would want to introduce our panelists who are already online. We have about 1 hour to make presentations, and each one of them will have about 20 minutes to make their presentation. Our first panelist is Miss Immaculate Angutoko Draru. She is already online and waiting to make her presentation. Miss Immaculate is the president of Uganda Association of Prosecutors. She has been with the DPP's office since 2005, and she has risen through the ranks, and currently she's in the position of a chief state attorney. Immaculate currently deputizes the Department of Research and Training, and therefore she's very well equipped for the topic of today. Miss Immaculate, you have 20 minutes, and the litigants here, or the members who are attending here, are very ready to receive from you as you share on the topic of the emerging realities or the modern practice in criminal law practice. So, Miss Immaculate, are you online?
Yes, Sylvia, I'm online.
Yes, I will introduce the other panelists as we go on. So, since you are our first speaker, I thought I should introduce you and we immediately start, since we're also behind in time. So you have 15 minutes, please. 15 minutes. And you're most welcome.
Thank you, Sylvia, and thank you, Uganda Law Society, for this opportunity to learn from my fellow distinguished panelists. For guidance, do you want me to have my video on, or this is okay? Because I would like to maybe make some presentations on slide.
Miss Immaculate would like to have your video on because it will keep us awake. It will keep us engaged with you, even though you're not physically here. So if you can, please put on your video.
Okay.
Thank you.
I can't see myself, so I hope I'm visible now. Yes, dear learned colleagues, it is a pleasure and honor for me to share experience and knowledge with all of you, as well as learn from my fellow distinguished panelists. As we can see, the topic that we have been assigned is quite wide. So Sylvia, I don't know how I'm going to handle it in 15 minutes or 20. I request that, I don't know if I have rights. I've sent a request to share my screen because I would like to have some slides. Okay. Okay, so I'll just move straight into the discussions. Already the topic has been shared with us. So my presentation is really going to focus on the perspective, or it will be from the lens of a prosecutor. As you're aware, I've been a prosecutor since 2005, so it's almost my entire career has been within here, though I've had opportunities to execute other tasks here and there. So the world, as the world
Hello?
evolves, the trends.
Miss Immaculate, would you share with us your presentation and we'll be the one to project it? It will be much more clearer if we are done sharing it. Huh? Okay, okay. I think the IT has been able to do it. It's okay, you can go ahead. They have projected it and it became more visible. Please go on.
Should I share again or I do not share it?
Share it even as you go
'Cause I
on,
stopped.
because in the event that it's not projected well from you, then they can be able to do it here. Share it, eh?
Okay, here it is. So as the world evolves, the trends evolve as well. And of course, when we speak about trends, these include crimes and its patterns as well. And the nature and pattern of crime is changing as well. And the threats that face continues to grow and evolve every single day. You can imagine when I joined the office of the DPP in 2005, I was not aware of so many of these crimes. I was mostly familiar with offenses under the Penal Code Act. However, as the years passed by, new offenses kept on emerging. And so I have to keep up with the trends. And moreover, criminal networks as well are becoming increasingly very resilient and adaptable. And they're exploiting the fast evolving technology to enable emerging types of crime and developing new methods of committing traditional crimes. So as we can see, yes, some of these crimes were already there before. However, there are now new methods of committing. Maybe before I go into what could be some of the implications, maybe we can just look at some of these examples. For some reason, I can't scroll. Okay. So what are the new or emerging trends of crime? This list is not exhaustive and it's in no particular order. We have terrorism under the Anti-Terrorism Act. We have cyber crimes. Under there, we could have offenses such as malware. We have online scams. We have hacking. We have cyberbullying, which is very common now. We have identity theft. We have phishing, we have online sexual harassment, child pornography, all these, I mean, some of these are under the Computer Misuse Act and some are not. And we also have money laundering now, which was not there before. This is catered for under the Anti-Money Laundering Act 2013. We have trafficking in persons. There are different categories of offenses there. I'm sorry, in the interest of time, I am not going to elaborate, but if you have specific questions, maybe you can note them down and you can ask those during the Q&A session. Then we have corruption-related offenses under the Anti-Corruption Act, which have also evolved over time. We have those specific offenses, for instance, consumer violations, where you have copyrights, you have imitations of genuine products. This is handled by the URSB. You have the UNBS offenses there under. And then there is a category, violent extremism. In our scenario, it falls under terrorism, but it could also be a separate offense of its own. We have offenses that are under them, offenses that are sexual, gender, and children related, such as child pornography that I had already mentioned. We have a new trend that is sextortion. We have economic crimes, which could also, some could be under the anti-corruption, I mean, could be corruption related, but you have fraud, tax related offenses that are handled by the URA. And now we have some gray areas as well. For instance, the cryptocurrency and virtual assets. Colleagues, if you can see, these are all new trends. They're emerging. Some are really gray. For instance, cryptocurrency. It hasn't been in our jurisdiction declared whether it's illegal or legal. It's quite gray to an extent. So, and some of these are traditional but committed using new methods, whereas some are yet to be criminalized in our jurisdiction. But I just outlined them for purposes of our discussion. So, since I've highlighted some of these offenses or new trends, I would like us to talk about some of the salient characteristics of these trends. One key thing is that now these crimes are transboundary in nature. Increasingly, you find that the number of offenses are cross-multiple, meaning they are committed within more than one jurisdiction, whereby you find that the evidence, the witnesses, the victims, the suspects, and the assets are located in more than one jurisdiction. And of course, as learned colleagues, we know the implications of that. Some of these are borderless offenses. For instance, offenses under the cybercrime. Yes, the category of cyber crimes. Some of these are committed in the dark web world, whereby there is no trace of the suspects. So it is very hard for investigators to locate where exactly this is. And it could also be that there is the location indicated there is a different one from where the actual offense was committed. Another characteristic is that it is constantly changing in nature. When these criminals realize that a particular method is already being pursued by law enforcement, they will change. For instance, if you have in Uganda, let me just give by way of maybe example, bank robberies, the robbing from these money agents, mobile money agents, you can see. So really, they do not have a set or constant kind of trend, but it keeps changing every other day. So that means that there is pressure on the law enforcement, there is pressure on the prosecutors, there is pressure on other actors in the justice system to also up their game to catch up with the new trends that are being utilized by these criminals. Another thing is that these are organized in nature, that it is very difficult to dismantle the system. You could arrest one person who is maybe just one of the participants in committing that offense, whereas the majority go without any trace of it. So that as well poses a challenge. And then they are highly complex in nature. Even me as a prosecutor, some of the modes of commission of these crimes are very hard for me to understand. They are committed with sophistication, especially those offenses that are committed using AI. Now, colleagues, in this era where you have proliferation of online software that allows users to change their selfies into digital avatars. So how are you going to, or the investigators going to investigate or unmask the person behind that? Well, behind it, in reality, it's a real person. However, they've changed it using digital methods. And then you have ChatGPT, which uses natural language to process or create human-like conversations. So you might think you're online, you're chatting with person X, whereas it's actually the computer that you're chatting with. So in that case, if somebody bullies you, if somebody harasses you sexually, if somebody commits an offense, how are you going to, whom are you going to arrest and charge as the suspect? Because in reality, it's actually not the person as such. So with AI, it is really very complicated. And therefore, it requires a lot of technical skills. It requires a lot of resources and time to investigate. And victims, in some instances, also may not be aware that these are criminal offenses. Oftentimes, they go unreported, or by the time they go and report, already it is hard to pursue the evidence. Already the evidence has been tampered with. If it was online, if it was using a computer, there have been changes. And we know the rules that govern evidence. So those pose as challenges to a prosecutor. So what challenges do these trends pose to a prosecutor? Sylvia, please let me know if I'm running out of time. I have about 10 slides in total, so you let me know so that I don't.
You have about 7 minutes.
Okay, I think I'll be in time. Thank you. So let's move into maybe discussing or just highlighting some of these challenges. Like I said, I will not be very elaborate given the time, but I'll be available to answer any specific questions. So what do these pose since we are doing litigation training today? As we should be aware, it is the prosecutor, it is us who bear the burden of proof. And this burden is to prove each and every ingredient of the offense. And the standard is beyond reasonable doubt. Therefore, the prosecutor, there has to be a shift in the way we also conduct business. Now, investigations, for us prosecutors, investigations are the bedrock of a successful criminal prosecution. Without the necessary evidence, you will hit a dead end. So we rely on the investigations that are conducted because that is where the evidence comes from. Without evidence, we are not going to court. Then there are issues of reliability. You have issues of authenticity and admissibility of evidence. So even if I already shared with you the salient features of the new trends of crimes that we have, and you know from there that it poses, if it is transboundary, how are you going to be able to gather evidence from one count to the other where you do not have mutual legal assistance agreements? Sometimes the jurisdictions, the laws are different. So that poses a challenge as well. Even if you bring the evidence, is it going to be admissible under the rules of this particular jurisdiction? So those are some of the challenges. This therefore calls for a shift in our approach as prosecutors, investigators, as well as other criminal justice stakeholders, including advocates in private practice, including the bench, judicial officers, to combat these new trends. As a prosecutor, what are some of those mitigative mechanisms for effective litigation of such crimes? Also, it is general, like I said. As Office of the DPP, we have the prosecution-led or guided investigations. That is right from the start, at the initial of it all, the prosecution is involved in investigations, not physical investigations, but we guide. And once some evidence is gathered, you meet and you discuss, and you also discuss the way forward. And that helps in bridging the gap. It helps in filling the gaps that may arise, which otherwise would not be possible if it was realized at a later stage. Then we have the inter-agency cooperation, where you exchange knowledge, ideas, and skills. That includes, for instance, between the prosecution authorities, say Uganda and Kenya. Then you also have between the investigating authorities, say you can use Interpol and all that. Then we have established specialized units. As you can see, these offenses that I highlighted, most of them require special skills, really specialized, because if you look at cyber crimes, the mode of commission is different. The kind of evidence required is different. So that requires really people who are skilled to do that particular one. Like I mentioned before, personally, when I joined the Office of the DPP in 2005, some of these offenses were unknown to me. So you can imagine that today, without training, without any specialized skills, if such a file would just be given to me without skilling me. So we have those specialized departments to cater for, to handle such specialized offenses. Then there is continuous training, of course, that is required regarding the emerging crimes. Another method when it goes to court is we have the option when it comes to decision to charge, to prefer charges that are traditional in nature. For instance, if there's a terrorist act, but you fail to gather evidence to prove the ingredients of terrorism, but there was death, and it's possible for you to prove murder, then you can resort to that. For instance, if you have aggravated trafficking in persons, and it involves sexual acts, say defilement, then you can opt for defilement, aggravated defilement, instead of an offense under the TIP Act. Then this morning, I know you had, I think, trial advocacy, something like that. My good friend Linda must have taken you through the trial advocacy and all that. So conduct of proper case analysis, and then you come up with a convincing case theory. You may keep refining this in the course of your prosecutions, but that really helps in putting your case across there and securing possibly a conviction. Then in some cases, especially offenses that are triable within the High Court, you can take advantage of the preliminary hearing which is allowed under Section 67 of the Trial and Indictment Act, to have some of these documents. If you think they are complex, you have them admitted. And that calls for collaboration with colleagues on the other side, the advocates who are for the accused persons. Then enhanced trial advocacy skills, which involves witness preparation, maintaining proper chain of evidence, whereby you're going to ask the right questions to the right witnesses, make the best use of the opportunity to make submissions, be it at a no case to answer or final submissions. Then make use of circumstantial evidence, because it's permissible in law. Instead of wanting direct evidence, if you can't find direct evidence, use the available circumstantial evidence that the investigative team was able to gather. And then, of course, use corroborative evidence as well to support where it is available. And as lawyers today, we cannot do without research. You must do extensive research, conduct extensive research. Like I said, these are evolving, they're emerging. So we may not have the sufficient or adequate jurisprudence to support, say, your submissions. So you can do comparative research, whereby you can rely on jurisprudence from other jurisdictions that are more advanced than us, then enhancing mutual legal assistance. And this doesn't have to necessarily be formal. It can be informal. For instance, here we have other entities such as the International Association of Prosecutors. They meet regularly. You have the institutional heads who meet. So if you have an informal, sorry, this was not supposed to be part of it. If you have an informal arrangement with your counterpart in another country, it can help, for instance, in preserving evidence as you follow the proper mutual legal assistance mechanism, say the requests. If you formalize, before you raise them, you can use your connections to ask for simple support or assistance in terms of preservation of evidence, some details. In some cases where the witnesses are cooperative, then you can pursue the formal mechanisms for mutual legal assistance. I think in brief, that is it from me. And unless there are questions later, I beg to stop here with my submissions, and I hope I did some bit of justice to the topic. Thank you, and over to you, Sylvia.
Thank you very much, Immaculate. Thank you for that detailed presentation. Even though our time is limited, I note that many of the trends that you are talking about, the new trends, have to do with technology. The growth or development in technology has changed the landscape of practice generally, not only criminal law, but practitioners have to embrace themselves with the new development in technology in order to really match up to what is happening. I think physical presence is no longer very key in issues of whether presenting of evidence, committing crimes. Things can be done without, physical presence can be dispensed with, like our meeting here today. The fact that we have panelists who are not physically with us in the meeting, it shows that even whether you are present in a place or not, things can actually go on. So thank you so much for your presentation. I ask that our audience will be able to send in questions. If we have questions in the chats, they can be able to have them answered at the end. We'll have a question and answer session. So let the questions be put in the chat. Otherwise, For the sake of time, I think I would want to get our next presenter, who is Mr. Evans Ocheng. He is a practitioner, a senior lawyer who has been engaged in criminal practice for a number of years. And I know that he is going to share with us practical ways to equip a litigant or a criminal law practitioner in the emerging developments or emerging trends. Mr. Evans, do we have you online? Mr. Evans? Mr. Evans, if you're muted, please unmute the microphone so that you can start your presentation. So even as we get ready to hear from Mr. Evans, as we've heard from Miss Immaculate, many of the emerging trends that we have today have to do with the changes in technology. I never thought that it was possible for an accused person to be present. I mean, to be absent in their own trial. I mean, that was new. That was really new. And I think COVID is then that forced us into that. The law had to be amended. People were in Luzira prisons and attending their trials. As a lawyer, you are proceeding without looking at your client. You can't even whisper to say, I mean, what am I going to do now? Somebody is miles away, but you are proceeding with a trial. And we have seen now with courts that a person can be in the UK and give evidence comfortably. Matters go on. We have seen that in the old system, your meticulous address of court, I mean, what made a lawyer was how well you presented yourself. And now suddenly, the one who has a quick pen or an excellent pen sometimes has the day. I mean, in the Court of Appeal, I was shocked that an appeal now takes about 10 minutes. You have 10 minutes of audience. You're adopting your submissions, and you're out. So criminal appeals are very interesting, and I think it's the same with the civil appeals. So really, technology has changed the landscape of criminal law practice. Mr. Ocheng, I'm not a speaker today. Where are you? If Mr. Ocheng is not... Okay. Our IT team, I think Mr. Ocheng wants you to unmute him or give him audience so that he can be able to address us. So Mr. Ocheng is a practitioner. I've seen him a lot in International Crimes Division, appeals, and so we want to hear how he has been able to overcome the challenges of the emerging trends. The emerging trends are both an advantage and disadvantage, but whatever the case is, we have to be able to cope with the changes and still be excellent at our game. So I know that we're going to have a very fruitful presentation from Mr. Evans. Is it an anomaly on our side or on his side? Okay. I don't know how we can help you, Mr. Ocheng. Find a way of unmuting yourself. I think he's getting a comment that the host is the one who should unmute him. He's asking that host kindly unmute. I'm considering getting on third speaker if Okay. Yeah, Mr. Cheng is back online. I still see that your microphone is still muted, so unmute. Okay, I think we're going to our third speaker, Mr. His Worship Kira Martins. Are you online? Technology can be a challenge, so we'll give Mr. Evans some time to adjust. Maybe the IT people can reach out to him and see how he can be assisted. But for the sake of time, I think we'll have to have the next speaker. Our next speaker is His Worship Kira Martins. His Worship Kira Martins is presently not also physically here with us. He's the acting chief magistrate of Pader, so I mean he's miles and miles away. He's also a professional advisor at the Law Development Center, and he has over 12 years of legal practice, and I know that he's very well equipped to be able to equip our attendees today on the trends that you have experienced as a judicial officer, but please advise us on how best to equip ourselves to be better practitioners. You are most welcome, Mr. Kiria.
I greet everyone in attendance, and I am humbled to be here. And I thank the ULS for thinking about me to be part of this litigation week for the CLE 2025. My name has been already said, Kiria Martins. I am an acting chief magistrate in Pade, where I am presenting from. I am unable to share my slides because the invitation to me came a bit late. So I had a very limited time to make preparations, but nevertheless, I am very ready to share my experience that I've gathered together with you people who have appeared before me, those that I've studied with and those that I've interacted with in different spaces. My colleague Imi has done justice, and when you talk about criminal law in a changing world and modern practice and emerging realities, many of the trends that she has already elaborated are the same. On the forum yesterday when we were trying to prepare, we sort of, should we prepare individually or we should prepare in form of a questionnaire? And I believe most of the things that she has tackled is what we are likely to regurgitate. So for purposes of not repeating what she has said, I propose to restrict myself on emerging issues or criminal tendencies in the Domestic Violence Act, institutional criminal proceedings, because it's one of the emerging area, and something to do with how to deliver sentences in a way of administering justice and not merely giving a judgment. So for a start, I will begin with institutional criminal proceedings in Uganda, which is one of the areas which has become trendy, including us judicial officers, from experience of the cases that I've handled. When you look at our law, the Constitution, the mandate to institute criminal proceedings is largely for the DPP. However, the same Constitution recognizes other individuals or entities or authorities to ensure that they have the right to institute criminal proceedings. And the ultimate mandate again goes back to the office of the DPP to either apply to continue with them and discontinue in some cases where they feel it is deemed to have the criminal proceedings terminated. But there are challenges which have come in because it has become too much that as a useful tool of instituting criminal proceedings in Uganda, very many people seem now to be yearning for it, as opposed to going mainstream by use of the office of the DPP. As such, we have all found ourselves entangled in interpreting the law as to what should we do, how should we handle this nature of process of criminal proceedings. You realize that when you look at the law, the constitution and the operational sections under the MCA, as a judicial officer, we are heavily involved in shaping the nature of these cases in our courts of law. We have a very big role to play, establishing a prima facie case upon a complaint which has been laid on our desk, then issuance of criminal summons to the suspect who may have been alleged to have committed that offense. There are stakeholders involved, including the local chief of the area, who could be the ward administrators in terms of town councils. Many questions have arisen in this area, including what is the method of commencement? Is it by a letter? We have seen some people institute criminal proceedings by way of a letter to a judicial officer. We have also seen others instituting notice of motion simply because they know the procedure is not well laid. And yet others come up with complaint on oath. Others have come to courts of law with an inquiry made from the office of the local chief, and yet others bring a bare complaint on us, requiring us to go ahead and conduct that inquiry in order to satisfy ourselves as to whether we should issue criminal summons or not. These are things which have been in our pothole. They have created a lot of confusion. The high courts have come up to shape this law, but many things have remained unresolved. As a judicial officer who has participated in shaping the inquiry, the investigation of this matter, then at the end of the day, you are supposed to draft a charge sheet together with the complainant in this matter. Where does it leave you if at the end of the day, you are supposed to hear the same matter? Are you therefore sitting as an investigating officer? Are you sitting as a judge? Where does all this leave your impartiality? And yet in the judicial code of conduct, one of the principles that we are supposed to adhere to as a judicial officer is the principle of impartiality. Our work as judicial officers is to administer justice, but now when a law allows you to mingle in the process of a build-up of a case, like in private prosecutions, you realize that at one angle, you are pitted in a way that your impartiality is likely to be compromised. That is the bit on criminal procedure in terms of how to institute the criminal proceedings. There are many schools of thought. When you look at other jurisdictions like South Africa, they restrict criminal private prosecutions to an angle where the office of the DPP has been informed of the commission of this offense by an individual, then they have neglected to take action. And therefore, the private means of institution of criminal proceedings comes in as a last resort for this individual who feels to have been aggrieved by the process, by the process of the DPP not to take action, and also feeling aggrieved by the suspect who injured him in a criminal way, that then the law would allow you to come in. In Uganda, ours is an alternative to institution which is a mandate of the DPP. So you realize that this new emerging trend of how many people are now yearning for the private way of instituting criminal cases is something which cannot go unnoticed within our criminal law as part of the changing world. Ms. Immaculate has talked about the other branches of law, cybercrime. I will restrict myself on domestic violence. We know this is a law which came in in 2010, and it came in order to address quite a number of issues which largely happen within our private sphere, within our bedrooms, within our homes. The experience that has revolved around this law is that, first of all, to begin with the definition, you realize that the definition is so wide to almost leave nothing unturned. It punishes emotional violence, economic violence, physical violence, economic abuse, physical, among other things. But then the question comes in this law is that when you interrogate it, the law seems not to give us the standard test upon which courts of law are supposed to use in order to determine that this nature of an insult to your spouse will land you into problems. So in courts of law, we find a very big challenge to interpret whether an abuse of this nature, because when you look at the law, it emphasizes repeated insults. When you look at the mainstream penal code, under threatening violence and the other kinds of threats, you realize that the interpretations which we have from the precedents, they try to downplay mere insults to amount to a criminal offense. But now when you look at the Domestic Violence Act, it criminalizes repeated insults, ridicule, name calling, verbal, emotional, psychological. But most important again is that they go ahead to tell you that even when these things are done by consent, with the consent of the victim, and the victim in the future or the following day finds that this, even if I consented, but I feel it was emotionally touching, he has a leverage to go back to court and have the family member charged with an offense of under Domestic Violence Act. Now, what are some of the challenges that we have on the bench? One is that these are cases which happen, like I said, in our families. The complainant is maybe the husband or the wife or the child. Now, these are people who are family members. As they come to court of law to complain, they are supposed to go back in the same home to reside. And this is where the perpetrator comes from. In Uganda, we have a challenge of lack of Witness Protection Act. Therefore, it compromises how serious these cases can be handled by courts of law. In such a way, we find ourselves on the bench now resorting to other means of resolving these disputes, which may include reconciliation, even when the matter is serious in nature. Because when you look at the law governing reconciliations, there are some cases which they try to limit in terms of reconciling parties. And yet the Constitution provides for it, but we will end up finding ourselves into reconciling these parties, even when the circumstances do not warrant so. Because at the end of the day, the complainants themselves come back to courts of law and request the court to resolve that matter in a particular manner. And remember, this is the key witness. He has come back to you and says, you know, as my husband is in prison, the landlord is knocking. Children have to go back to school. You find yourselves entangled in a way that as practitioners, we may need to reconsider our methods of work. As a lawyer, we may need to listen to these people and not be part of the case, but try to resolve this matter in as how they feel justice will come at the end of the day. I listened to the panel which was dealing with the corporate, and there was an emphasis that as lawyers, it is not about going to court to win cases. The question is that going to give justice to your client? So time has come that we need to refocus and put on lenses which are aimed at administering justice to the aspirations of the people as per the Constitution demands, than getting judgment even when it bears no justice at all. Now, when you look at that law again, it limits very many things, including, and the emotional part of it, or the economic abuse. It tells you that when someone touches property where both parties have shared interests, unreasonably, at the end of the day, that person can complain and it will become an offense. But we all understand we are from families. Not all times in the family are rosy. Today, it may be ABCD. Tomorrow, you have stress because of ABCD. Then at the end of the day, you feel like, hey, well, I don't have money. I need to, use these funds or touch this property I got and pay school fees for children. Many times, because of the emotions involved, you find that one of the partner may not be willing to do that. And yet, you are doing it for the good cause. But because he suspects that maybe you may use that money for other bad things in her or his view, if you find yourself entangled in a situation that you cannot help your family because of fear of the sanctions. Now, when you look at the way this act again is crafted, you find yourself as a judicial officer in a dilemma of what is the sufficient sentence to be given if this person is convicted. We are aware of the victim's rights, but many times when these cases come on the bench, which I interest the lawyers also to understand, is that when we ask the victims, what do you want us to do? Since this man has been, or woman has been found guilty, many times they tell us, forgive. Many times they tell us, out of emotions, convict. I'll give you an example. When I was in Cavalry, a man was brought for domestic violence. He had assaulted the wife, so they filed it as domestic violence. The man pleaded guilty. Then now, upon the plea of guilty, as we are aware, the law says you can give either a fine of about 960,000 Uganda shillings, or imprisonment for a term not exceeding 2 years, or both, plus compensation. I asked the victim, what do you want this court to do for you, as in a way of enforcing the victim's rights? The woman said, I want to be compensated, but I don't want my husband to go to prison, meaning she was suggesting a compensation and maybe a fine. I asked the man in mitigation, what do you have to say? The man accused the convict told me, I am willing to compensate and pay fine since she has not opted for custodial sentence. However, I am requesting this honorable court to allow me time. I go and sell off our matrimonial home because that's the only property that we have that I can be able to get fees. To get money. That's when I saw the victim stand up and said, if that's the case, leave him to go, because then he cannot sell off our property, which we use as our sustenance in order to compensate me. At the end of the day, I realized that justice is in clearly understanding the needs of these people and perhaps interrogating them even before the matter comes to the end to ensure that we understand the needs of both parties when we are adjudicating these cases. And for us on that bench, we believe lawyers have a very big role to play.
Your Worship,
They
time
have been
check.
talking about mediation.
Your Worship, time check. You have
so
about
at
3
the-
minutes to conclude.
Thank you. Thank you. So at the end of the day, we realize that lawyers play a very big role in helping us advance some of these ADRs, reconciliations in criminal cases. With that, I believe I can wait for the questions as they come in. Thank you very much.
Thank you very much, Your Worship, and sorry for cutting you short. I just realized that our third speaker will have very little time, and yet it's important that we also hear from him. I encourage any questions in the chats. Please keep the questions coming. If there is any issue that you think is worthy of us just delving into, please put it in the question. Mr. Ocheng, I see you are here before I call out your name. You're most welcome, Mr. Ocheng. We are happy to hear from you. And we have already shared the topic that I know is very relevant to you as a practitioner in criminal law. And please give us pointers as practitioners. What are those pointers that would make us shine as criminal law practitioners? What are those areas that you have observed that need attention of a practitioner to look out for? Mr. Cheng, you are most welcome. Please make your presentation. You have 15 minutes.
Thank you very much. I believe you can hear me now.
We can hear you.
Yes. First, apologies. I was struggling to unmute and I was getting challenges, but finally I'm on. Well, I want to thank you for the opportunity.
Mr. Cheng,
address
is it
our
possible? Is it possible for us to have you on video?
Yeah. Yes.
Please put on the video so that we are able to at least physically see you. Beautiful. Thank you.
You can see me?
Yes, we can see you.
Yes, I am struggling. We are struggling to go back to court, but I wish to indicate that as a practitioner, first, I have had the benefit of listening to Angotuko. She has highlighted, my sister has highlighted in detail the new areas.
Mr. Cheng, we recognize that you are in motion, so maybe we can dispense with the video.
Yeah. Okay.
Yes.
So I would wish to indicate that as a private practitioner, particularly where I am concerning defense, I wish to indicate that the private practitioner needs to prepare heavily. Unlike the prosecution and maybe court, which may have some support from government organized trainings, you realize most of the trainings touching on defense can maybe come from the law society, or unless it is a personal initiative where as an individual you have enrolled to train and acquire a skill in a particular area. So I wish to advise and submit that the listeners, particularly those appearing privately on defense, have prepare and be alive to the emerging trends. From the defense perspective, we are almost not having cases of theft where people come and break into the doors and windows, but you still hear huge sums of money have been stolen through advancement in technology. So we must take charge of training in advancement in technology. We must also ensure that we are alive to the amendments, we are alive to the latest precedents on any given area of the law. Otherwise, we are also dealing lately with the sophisticated crime. A lot has been highlighted about the computer misuse and all those laws. A lot has been highlighted about terrorism and terrorism finance and how sophisticated crime has advanced. So basically, as defense, we have to ensure that we are up to speed. We have to ensure that we catch up with the prosecution. But also, we are noting maybe there is also a lack of training, maybe in the officers handling some of these cases. You will note that as the prosecution or the defense were equipping, you realize even the investigators, some of them are not equipped. So basically, I wish to point out that Susan, a defense lawyer must be alive to all aspects of technology. You will not, like recently, when we were having this trial of the MPs, particularly on admissibility of the recordings. Those who may have had the opportunity to follow the case, you could see the challenges the prosecution were getting, particularly to admit a recording. Yet maybe this recording has evidence. So I call upon my colleagues that we must learn how to handle that. We must learn how to handle those cyber-related evidence. You would also note that even these days when it comes to sexual or gender-based violence, the technology has increased. It's no longer I was defiled, it's no longer I was raped. You will see that there is a lot of analysis done, the swabbing which has come in. So we need to understand all this. What does swabbing mean? There is a lot of involvement of the DNA in evidence and in cases, in the trials. As a private practitioner, you are supposed also to be abreast. How do you deal with the DNA evidence if you are confronted with it? How do you deal with the swab evidence if you are confronted with it? How do you deal with gunshot residue? If you recall, dear listeners, you may recall the case which we were trying, the one that involved Kanyamunyu, Matthew. You remember the evidence was largely gunshot residue. Gunshot residues are just these powders that spill off. They are failing to trace the gun, but they are tracing on you or on your clothing gunshot residue. So we are asking, I'm asking my land colleagues, my friends, that we need a lot of training in these areas. They are real. We can't do much without them. We can't avoid them, because if you avoid them, then we are equally out of business. So basically, I would also wish to indicate and thank maybe the Uganda Law Society for organizing. We need more of this training. How I wish that these trainings could also be narrowed in a particular area, because if you look at the topic, the modern practices and emerging realities. There's quite so many. How I wish that we could focus on one or two and then we have exhaustive discussion on it. And then maybe the next training, we also focus on another trend. We identify the trend, we focus on it, and also have exhaustive discussion. Otherwise, I wish to thank you. Maybe I will leave my remaining minutes for questions and answers.
Okay, thank you very much, Mr. Cheng. And since you're then in motion, I am scared I might lose you, so I'll give you the first question. As we wait for any other questions in the chat room. Mr. Cheng, what has been your experience with the Prevention of Trafficking in Persons Act? I know that it's an enactment that also caused some kind of changes that were very different from our traditional Penal Code Act. What has been your experience and your interaction with defending accused persons who are charged under that act? Mr. Cheng,
I think you can hear me.
We can hear you. Cheng? Mr.
Can you be able to hear me?
Yes, we can hear you loud and clear.
Yes, I think my comment may not be well with some people, but nonetheless, I have to make my comment here. These offenses related to trafficking are being charged under the International Crimes Division lately. That is the trend, though other courts are also able to try them. But I wish to boldly indicate that we are seeing a trend where ordinary defilement cases are being converted into trafficking, and Madam Moderator, I'm sure you also practice in that. You could have seen that trend. So we are finding difficulty in drawing a line in an ordinary
We've lost you, Mr. Cheng.
You can hear me now?
Yes, please.
It appears if they don't want you to be released, then it is defilement is converted into trafficking, and there you find yourself into the International Criminal Division. So I think that law vis-a-vis the normal penal sanction, the normal legislation on defilement and those others need to be reviewed so that a line is clearly drawn. Otherwise, I have a lot of reservation with these trafficking cases where they are almost turning political because of the court. Thank you very much.
If there are any other questions, I'll let you know. But for now, I would want to pose this question to Miss Immaculate. Miss Immaculate, are you still online? I can see you're still online. But we are aware that in criminal matters, it is Uganda versus somebody. And so Uganda is the offended party. What is your opinion about the meaning of justice for victims and the interests of justice actors like members of the DPP? We've heard from His Worship talking about an incident where a victim is having a different opinion of what would be justice to them, and yet if a representative from the DPP's office would probably be a different line of sticking to what the law should be, whether it's a penal sanction or a fine or what. So Miss Immaculate, can you hear me?
Yes, Sylvia.
Yes. I am sure that during your long practice as a prosecutor, you've had situations where victims are thinking about justice in ways that are very different from what our statute laws say. In such incidents, how do you handle situations where a victim would want you to release their person, where a person is interested in compensation and not in imprisonment of somebody, where a victim is probably emotionally attached to their offender. So I would want you to make a comment on that, the meaning of justice for victims or the society or our cultural norms as opposed to what is in our statute books.
Thank you, Sylvia. This is a tricky one, but of course, as a prosecutor, our interest is that justice prevails in all fairness. So it is that if somebody indeed committed an offense, he or she must be punished for that offense, and the punishment must be appropriate. So what determines appropriateness of the punishment from our perspective is usually the punishments that are provided under the provisions of the law. However, now largely our laws and the courts involving victims in all these trials. And then you know that we rely on evidence in our prosecutorial duties. So, and in most cases, and especially when it comes to offenses, say even sexual related offenses, you have your key witness is the victim. So now that calls for the need to balance, the need to protect the society, the interest of the victim, and the law, the application of the law itself. So sometimes it calls for a compromise, because in a scenario whereby your victim is the key witness and stands there in open court and says, no, I'm pregnant, I'm expecting, say, aggravated defilement. I'm expecting a child from this accused person, therefore I want him to be released so that he can take care of the baby. And courts are going to quote for you Article, is it 126, which says reconciliation should be promoted. And here you are wielding your Penal Code Act and saying that, no, this offense attracts a maximum of death sentence. But your main witness is here in open court and says, no, I don't want. So really, you have to strike a balance in that scenario. How it varies, it depends on a case by case. Now, because here I've given whereby there is a child involved and the future of that child is at stake. But there are also others whereby, like in offenses, also gender-related offenses or trafficking in persons. You know that sometimes there is the, what is it called? That syndrome, whereby the victims are so attracted to the perpetrators of the crime that they are not cooperating with the prosecution itself. So really, I think it is very difficult for me to have a stand, whereas every case has its own facts. So I think we are guided by the circumstances at the time, the available evidence to strike a balance in such scenarios. I hope that answers you. Thank you so much.
Thank you. I have not seen any questions so far in the chat section. So I will.
I have one question. I think someone asked me to expound on trafficking in persons. However, that person also asked me to comment about, in light of a judicial officer who has been convicted in another jurisdiction. I think for me that is sub judice, but I can make a comment on the offense of trafficking in persons. Now, my colleague Evans has issues with that. But as we know, and from a prosecutor's perspective, I just mentioned during my submissions that we have the burden of proof, and the burden is to prove each and every ingredient of the offense. So really, it would, in my view, be unprofessional for a prosecutor to peruse a file and without evidence supporting each and every ingredient of that particular offense to sanction it. So I really think it's just a perception, because we know that we have the burden of proof, and that burden is beyond reasonable doubt. Therefore, when I'm perusing a file, what guides me into preference of the most appropriate offense is the available evidence. And for trafficking in persons, you know that there are three things. There is the act, there is the means, and there is the purpose. So for the act, there has to be either recruitment, transportation, transfer, harboring, or receiving of a person. The means, it could be use of force or other forms of coercion, fraud, deception, abuse of power, etc. Then the purpose must also be specific, to engage that person in prostitution, pornography, sexual servitude, exploitation, forced labor. So really, by the time I sanction, I must ensure that I have the evidence on file or on record to prove each of these three. So I don't really think that we just sanction or we are, because aggravated defilement has different ingredients from what I have just listed here. There has to be sexual intercourse, participation of the accused person, and then age. Of course, here we have aggravated trafficking in persons, but the three things have to be there. The act, the means, and purpose that I have highlighted must also be present. So I think it's just a perception. And in any case, even if we do that, at the end, that person would be acquitted. Thank you.
I have questions here that are going to come from my neighbor.
Thank you very much, moderator. Good afternoon, everyone. I thank the precurrent speakers. My name is Kiega Hatwib. I have a question for Miss Immaculate and His Worship Martins. My question for Miss Immaculate is, what is your comment on the continued criminalization of civil matters? You would agree with me that maybe your office has seen quite a number of complaints, despite the fact that we have had jurisprudence vehemently disdaining the criminalizing of civil matters, and it still persists. You see a clear contract, you see a clear breach of that contract, but somehow state attorneys continue to sanction these files. And you ask yourself, what are we going to then prosecute? And unfortunately, even when you raise these issues, somehow they still, persist, and eventually it frustrates us as defense lawyers or defense attorneys. Maybe you would take that, then I'll ask Mr. Martin's question later. Oh, I can ask it. Okay, thank you very much. For His Worship Martins, my question to you, sir, is what is your comment, again, about, I don't know, the cropping nature of judicial officers who do not, I do not want to bring it in a way like as if it's a bar bench, but they do not take account, or they do not consider what we believe is reasonable doubt. That's one. The second limb of that question, we have judicial officers, both on the higher bar and the lower bar, who are known for not even acquitting at the level of a prima facie case. We have a matter where we believed, because this matter was a statutory crime of intermeddling with the estate of the deceased, we believed we had proved that a few elements of the offense were not proved by prosecution. Nonetheless, the judicial officer vehemently intimated that we shall be put to our defense, that our client will be put to our defense. So, Your Honor, at this point, I therefore ask, what would you advise us to do? Because at that point, we think we have actually represented or ably represented our clients. Thank you very much.
We'll have a comment from, okay, we have other people here with their questions. So let's take the questions and then we'll have our panelists answer. So when you are making your question, make sure you indicate to which particular panelist the question is going to. Yes, please.
Thank you so much. I have been listening into Miss Immaculate and His Worship, Kyria, and I think he raised something about witness protection. Yeah, in terms of the nature of criminal law or offenses, and my heart went out to mainly sexual offenses, like related cases of sexual offenses, because I know that most women actually, or girls or families, feel shy to even report some of these cases because of the stigma associated, or the want of evidence, or the preservation itself, you know. Yeah, I think years back there was a case on female genital mutilation. I'm talking about sexual reproductive health rights. Of course, that's my area of practice, like an area of interest. And I was bamboozled when, you know, the case was thrown out because the person failed to show up with the specimen, the cut-off genitalia. Yes, I don't know if you guys heard that, but it was some story that was trending. But you know, you have an act that is in place to try to, you know, curb. Then the courts that are supposed to be proactive, or the, you know, legal minds that are supposed to be progressive are not helping the situation, because I think some offenses should go beyond statutes and the law to I don't know if it's called morality, but, you know, be proactive, think beyond what is inside there for you to adjudicate, or, you know, justice to prevail. So I think for me it's a comment, but also pondering that we need to think beyond what is cut out already, because most offenses against women and girls don't see daylight. And if we have very few cases that are successfully litigated or whatever it is, and they don't see daylight, it means that very few women and girls will believe in the justice system. So for me it's a plea, like when you're handling sexual related offenses, don't look at them like the usual, like commercial and all these. These are people, these are people's lives. So I also want to marry it to witness protection. What are we doing to ensure that girls and women are not cornered or, you know, traumatized to report or speak? Because abuse happens in well-organized settings. It could be in homes, in offices, in communities. But what happens, because the narrative touches on the victim and she becomes more victimized, we don't look at the perpetrators. And then finally, on emerging trends, since we're talking about emerging trends, we'll look at murder, we'll look at all this, but I'll still come back to sexual reproductive health rights. When you're looking at justice, again, like there's reparation and there's justice that goes beyond the statute. So I am defiled. And then you say, for example, sentence someone community service, so how many years in prison? And this girl is left pregnant. The law on abortion is very restrictive. She's been defiled and raped. And on top of that, this person is not going to undo some harm, like, for example, defiled and left with HIV. You see, the burden that this human is going to face for a lifetime. So how are we getting proactive? Because criminal justice goes beyond when we're talking about humanities. So let's also look at what is happening in other jurisdictions. The Mexicans have done well in reproductive justice. And also the bench, also the prosecutors also interesting themselves in emerging trends that touch the persons of the people, like in communities, beyond other criminal offenses. We need to torch a light on sexual reproductive health rights and related offenses. Thank you.
If that question is for Miss Immaculate? Okay. Yes, please.
Thank you so much. My name is Musimenda Stewart, and I want to ask my question having read this quote. It's from one of the recent rulings, and it says the judge held, therefore, although I find the applicants have satisfied all the relevant requirements for the grant of bail, such as proving that they have fixed places of abode, have substantial sureties, are first-time offenders with no criminal record, and of advanced age, the application for bail is denied for the following reasons. I won't read the reasons, you all read the judgment. But I wanted to ask His Worship Kiria, since we are discussing emerging realities, when it comes to bail applications, are there emerging realities that practitioners need to know? Because I'm imagining court of record is stating that all conditions have been satisfied, but then bail is denied on the other issues. Then Miss Immaculate, maybe since you come from the state, so and my question is still on bail applications, and by that I'm asking as a criminal student, not as a practitioner. But has you as state prosecutors, are you, when you are trying to argue against these bail applications, are we actually basing on the law, or there are actually other hidden realities that we need to know about as practitioners? Thank you.
Question, and then after we'll have our panelists answer the questions. We'll start with His Worship Kiria, then we'll have Immaculate, Miss Immaculate, and if there is any other question that has to be answered, then Ms. Sao Chen will answer.
Okay. My name is Kenneth Majora. My question, I think, will go to Mrs. Immaculate. My concern is on the, I think, on the procedure for preparing the charge sheet, you identifying the offenses and preparing those documents. Who prepares what, who guides who, and who approves those offenses or charges on the charge sheet? Because I think there is also an emerging trend where prosecutors or whoever crafts those charges simply put offenses of their choice without consulting the law books. And because we recently, we're seeing decisions where cases are being dismissed for defective charge sheets. We have also recently had, I think, a heated debate between one of the judges of the High Court and the prosecution on, I think it was related to rape, on where the child can be raped, because there was also that discussion. So we want to understand who sets, who decides. Is it the law, or is it some things we don't know that you probably are following a certain script? And also this goes to politically motivated cases. Thank you.
Thank you, Immaculate. You have probably 3 minutes to answer the questions that were addressed to you. You have the floor, Immaculate.
I don't think that's fair. 3 minutes, I can't. There are about 4 minutes, 4 questions. The first was, I think, about criminalizing of civil matters. I must say that I think here some of these questions should have been most appropriate to my colleague, His Worship Martins, because if you can see, and those who have followed jurisprudence, we have authorities that say there is no bar to having both civil and criminal matters concurrently. And these are authorities' decisions from the Supreme Court itself. So the controversy mainly is mostly from those decisions by judicial officers. It is not us, because we know the doctrine of precedence. If the highest authority, that is court, has set a precedent, had made a decision that yes, there is no bar to having both civil and criminal matters concurrently. In fact, criminal matters take precedence. Then, unless that has been overturned by the same court, they differ from it, then I think the law should be that that is the precedence which we should follow. Now, by way of example, I think it goes back to the analysis of evidence. In a scenario whereby you have parties, two parties have dispute over land. Yes, there is no proper determination. This one is saying, I own it, I bought it from this, maybe customary. Another says, I have a land title. And then one party takes the law into their hands and goes and destroys, say, puts down property that is on that land. To be honest, you expect us not to sanction charges against that for malicious damage of property? Why would they take the law into their hands instead of pursuing a civil matter to determine ownership and waiting for that decision? So really there are scenarios whereby you clearly see that whereas there is a civil matter for determination of ownership, there is a criminal one as well, malicious damage to property. The ingredients are there. So we sanction in such scenarios. And then the issue of witness protection. It's true we do not have a witness protection law. It has been in drafting for long, and I think one of the issues is who is going to be the host, something like that. There's still issues, but we are moving fast forward, and I hopefully in the near future we will have a law in place. However, for now, we collaborate with other civil society organizations. That is for matters that for protection outside court. We have some of these CSOs that provide shelters, that take on some of these victims, especially of sexual offenses. And then in court, during trials, we also can normally pray for those protective measures. I think it's common in ICD and also in children and gender-related offenses. For instance, you can ask for camera hearings, voice distortion. So you can always pray as a prosecutor to protect these victims. But of course, the law is not yet in place, and it takes all of us to advocate that the law is passed. And of course, you know who passes the law. It is not the office of the DPP. And about the female genital mutilation, in fact, there is a law in place, that is the Prohibition of the Female Genital Mutilation Act since 2010. But I think there are regulations or rules that are lacking, and it prohibits that practice of female genital mutilation. But the problem is the communities are not yet sensitized. Some communities think this is something normal. So who is going to report? Not even the victim, because of fear. And that goes back to the protective measures we are talking about. The victim is going to fear to report. The community is not going to report. And even if it's reported, the witnesses are not going to turn up. So who are you going to rely on as your witnesses to successfully prosecute such cases? So we need concerted efforts, sensitization, laws in place, and full enforcement by all the actors that are supposed to enforce the laws. Regarding bail, someone asked the procedure for, are prosecutors basing on the law or hidden realities for bail? I think each case has its own facts, and it is those facts that guide us, and also the documents that support the application. For instance, if you attach documents, sureties, and in our view they are not substantial, we will object to that. If we feel that you're a flight risk, we'll object to that, because ultimately the interest is that the accused person returns to court to answer the charges whenever required until it is concluded to its logical conclusion. Because if you let go and then the person absconds, it's going to be another burden to start tracing for this person. So really I think it's a case-by-case basis. And in all honesty, there are instances whereby we have prayed for appropriate terms, not objecting as such. So we should not be looked at like we are just there to object to bail at all times, but the circumstances of the case vary and they guide us. But what you know is sometimes even if we object and roll down on the ground, the discretion is for the court. So whether you wail in court, whatever you do at the end, it has to be the judicial officer to either grant or decline to grant that bail. But on both sides, of course, you look at the interest of the victim. You look at, you as the advocates, you're looking at the interest of the accused person. So really, we do our best depending on the circumstances of the case. And finally, I think there was a question on who prepares charge sheets. Our charge sheets are prepared by police officers. We have specimen charge sheets. However, it is the duty of the prosecutor to peruse and ensure that the charge sheet is in compliance with the law before endorsing. There's what we call sanctioning. It is an administrative mechanism whereby the prosecutor endorses those charges. So if you find that there are some charges that are defective, there we should really take the blame, because the police are not legal minds. Well, some may be lawyers, but it is us who are the lawyers, and we are supposed to guide them. So if you sanction a defective charge, that one we take the blame. Thank you.
Thank you, Immaculate. I think I would want to hear a comment from His Worship concerning the question on bail.
Thank you very much, Sylvia. The question pertains to whether there are emerging realities or issues in bail. The answer to me is yes. I want to take an example where you are a judicial officer. Sureties come before you, and you have no way to verify whether they are substantial or not. What is emerging of late, when I was working in Kampala, is that the state attorneys would ask, I want to ask a few questions to the sureties, because most of them have come and they are saying they are relatives of the accused person. You dare give a chance? They ask, surety number one in confidence, he will mention, I am the father of the accused person. Surety number two, whether you know surety number one, he will tell you, I know him because he is a family friend. Yet again, surety number two is also saying, I am a father of the accused person. Now, when the law comes in to ensure that those emerging realities are catered for. Now, at the end of the day, you realize that that inquiry which has been done in the absence of the other surety has helped the court to know that these sureties either have been hired, and therefore it helps one to make an informed decision whether they are truthful or not truthful. I am aware of the specificity of the question in regard to a decision of the court, which I really don't want to go much into, but what is important to know is that the circumstances of the file or the case which is before you will guide a judicial officer on how to exercise the discretion as to whether the judicial officer is right or wrong. And he has given a judgment. I am very sure that judgment, there is a process upon which it can be challenged. But since we are discussing about an already decided case, and at my capacity, really, I'm not a spokesperson, but I'm also bound by the same decision. But what I pick from there is that a person will give an interpretation as to what he feels injustice that is what's supposed to be done. I want to believe that maybe the circumstances in that file for the person who actually handled it were warranted. So I cannot really give a conclusive aspect on it because I did not interface with the facts which were in that file to exactly tell whether he was right or wrong. But even when he was wrong, of course our system is very...
Worship, we lost you there for a moment. We can't hear you. Your Worship, can you hear us? I think you have a network problem and we're not able to hear you. So I would, hello? No, he's actually off now. Okay, well, we've had, I think, comments from or answers to questions that have been posed to the speakers. We are coming to a close of this session, and I want to thank the people who have attended, whether online or the ones who are present here with us physically. Thank you so much. Just a closing remark. I recognize that despite the fact that we are talking about the trends and the new things that are in criminal law practice, there are so many old things that are still ancient and tried and true. And I think for a criminal practitioner, just like any other field of practice, there is what they call preparation, and preparation. So if we're talking about emerging trends, then we need to read up and read up and read up. Because if you're going to be a good practitioner, then you need to know what you're talking about. So no matter how many trends come, preparation will never be old. And then there is the issue of interview. If you're representing somebody in a criminal law matter, many times they're not in their great period of understanding, I would say. And I say it in a very humble way because criminal prosecution is a traumatizing event for everybody. One interview is not enough. What they tell you today may be different from what they'll tell you tomorrow and what they tell you the other day. So interview. Even as you're going on with the trial, interview again and again. I think it is an old practice, and despite the trends, it doesn't get old. Another comment about the trends is knowing the law. I think as the panelists were sharing, we were seeing they're talking about certain legislations that have come in. I think Prevention of Trafficking in Persons Act is one of them. I saw a comment in our chat section. Somebody was requesting that we make a comment on that. Miss Immaculate did so. But I realized, as one of the practitioners who was up in arms about this Prevention of Trafficking in Persons Act, we saw a new trend where offenses which we traditionally considered as aggravated defilement or even defilement, and they had been now charged as Prevention in Trafficking Act. But when I went back and read the act, I had nothing useful to say. When they are enacting laws and we keep quiet, it is too late once they have been passed. Because once you read the law, you realize it is a blanket that covered everything. Once you're handling a child, just know you're a candidate for trafficking. Because if that child is, for instance, you have a child working at your home and you pay them an amount of money which is below what is considered reasonable, that can be trafficking. If you make them work and they're working, the work that they're doing is cumbersome, and it is beyond what a reasonable person should call normal, that can be trafficking. So under the Trafficking Act, it's such a big blanket that it makes us very careful how you deal with children. Once you have a child in your care, be very careful. Otherwise, you'll be a candidate for a charge under the Prevention of Trafficking in Persons Act. So knowing the law is one of the things that, as we're talking about changing trends, please know the law. And maybe even better still, instead of looking at the postmortem, let us be very alert when laws are being enacted, to be active enough to give our opinions, so that whatever ends up in our statute laws is not something that we're going to complain about. So I stopped complaining with the DPP charging under the Prevention of Trafficking in Persons Act after I read the act, because the act has empowered them. It is there. They'll quote the section, and when you go to court, the ingredients of the offense are there, and therefore there is nothing that you can do unless you change the law. And so I really want to thank you so much. I recognize that criminal law is actually the face of justice in our society. Many of us are very active in other areas of the law. Criminal law may not be a practice that you are very well versed with, but it is such an important aspect of the law because, as a judge once said, give me freedom, because freedom is the basis of life. If you don't have freedom, you don't have life. And so criminal law becomes very central. So I want to thank Uganda Law Society, the organizers of this training. Thank you for giving us this opportunity to discuss the emerging trends in criminal law practice. I want to thank our panelists, Miss Immaculate. Thank you so much for the time that you have given us and the information that you have shared here. Mr. Evans Ocheng, thank you so much. I recognize that you are highly engaged on this day, but thank you for putting the time. And His Worship Kyria Martins, thank you so much for your time. And for people here, thank you so much. We have come to the end of this session. Have a good evening. I want to hand back to our MC.
Okay, thank you so much, Sylvia. I think law is diverse, it's broad. If it's an area of speciality, either in or you switch it and you come back, but you know that you're a potential client beyond defending. Hey, that's how life is. It turns. I read a joke where they were saying that imagine plants, they keep giving us oxygen only to feed on us when we die. So that's how life is. You have to always be alert. And any opportunity to embrace any information or new learnings is a rare one. And especially when you're hearing from different voices that are in the depth of it. So we thank you so much, the moderator and the panelists. The speakers, sorry, I think there were more of speakers. His Worship and her. What would be the title? Miss Immaculate, yes. I think you could tell that she's shared from experience. And throughout, issues to do with evidence collection within the emerging AI era is becoming something else. And I think what's also critical is the collaborations we need to partake in, especially when it comes to witness protection. I know that there's been a draft that has been in the offing, but it's not taking off like our economy. Sweet. So again, it's a call to us to be alert and proactive. And when they call upon us to, sit with Uganda Law Reform or Parliament, or when Uganda Law Society calls out for us to review these laws, let's be attentive because we are the users. So we don't want to reach and we are reading laws and it's like we are reading Chinese. We have to be very alert. I think you've done well. Adults in a room the whole day is not easy. Yeah, so many distractions, class, phone, lunch. So we call today a day, and we thank the online participants too for self-monitoring yourselves. There's so many comments that have come through. It's only fair that we read out a few, yeah? Because we didn't read out any. The comments, Kamya, who says the state attorneys are misusing the Trafficking in Persons Act. They charge aggravated trafficking in persons when the purpose does not meet the element of trafficking, and all they say is, let the person be tried by the higher court, since it saves some of them the burden of conducting the trial. And then Viola Chaterekera says, in regard to bail applications, we may refer to the Constitution, bail guidelines for courts of judicature, then practice directions of 2022. Again, that is legal counsel guidance in terms of managing bail-related applications. And then there's Isaac Ronald Olanya, who says, sometimes the judicial officers really take advantage of their discretion, which in my understanding must be exercised judiciously to serve the interest of the executive. Okay? There is really need to strive for an independent judiciary where judicial officers are free to pass judgment without the fear of losing their jobs. Then these are more of commentaries for us to reflect on in comparison to what's happening. And then most of the other notes that have come through are really appreciation notes. Yes, and I think right now we have about 109 online participants. I think we're not doing badly. So face-to-face participants, you've really been amazing. And whenever we are called to serve, let's serve. It's our society and it's not going anywhere. So when Doreen reaches out, when the society reaches out, serve. Serve. I think it's the spirit that we are saying, giving back, mentorship. Because at the end of the day, people are phasing out. Today you had Sidia Council Rakafuzi, tomorrow he's not there. So that's what happens. You know, tomorrow you have Justice, what was his, the one who loved the environment a lot. Kakuru with us, tomorrow he's not. We also have young lawyers, you know. So let's not take these spaces for granted, but also keep in touch with Uganda Law Society. Express your areas of interest. Some of us come on these stages not because we're experts, because we feel like it's an opportunity to learn, to bury our fears, to express. Someone was in Supreme Court, and when they were making submissions, they were sweating, the armpits and all, the council, and we're always wearing white shirts, isn't it? I don't know how the sweat came through the suit, but so the lesson today is be proactive, show up, young lawyers. Don't wait to be given that space. Knock. Some doors are slightly closed, so push. Push, and eventually you'll align. You'll find where you like, and you'll settle in there. She's been talking about criminal law with a passion, and I'm like, wow, most of us run away from it, but you see. And so if you feel like that is your line, reach out. These spaces are for networking too. Get those contacts, reach out, and enrich yourself. I think with that, I can only plead with you to be here with us tomorrow for day 2. It's quite an interesting lineup. We've quite managed time today. We pray that God grants you journey masses. Those still mourning the Pope, it's a deep loss for the Catholic institution, because that voice shapes a lot of our society's beliefs, even the law sometimes, especially laws around morality. So with that, I wish you a good evening. Maybe Doreen, do you want to say something, or we can call it a day? That's all you want to say? Okay, so tomorrow we start at 9. So come open to learn, open to share. Good evening. Oh, there's evening tea too. Please don't rush into the traffic or carry bites through the traffic. Yeah.